Hello. Your attorney is ill, so they can't make it today.
Oh,
We're gonna give you a reset, okay?
okay.
Miss Ferguson,
I understood to get the video right. But he never called.
all right,
me.
so here's the thing. We're gonna recall it in 14 days. And then your attorney can be here, and if you feel as though there's something that he hasn't done or you would like to have done, you can discuss it with him. But what I can tell you is normally attorneys, they're in charge of your case, so they know what is good evidence for you and what is not, okay?
He had called me, but I mean, he was supposed to call me.
All right, so what I'm telling you, he's ill.
Okay.
All right.
All right.
Miss Ferguson, I need a 2-week reset. All right, it's gonna be August 4th. Once you sign the reset form, you're excused.
Thank you.
You're welcome. All right, who's here on Ricardo Salas?
I am.
And where's Mr. Salas?
He's in custody.
All right, if you'll come down. And are you all ready to proceed on the motion?
Yes, yes and no.
What does that mean?
Okay, well, I'm not ready. I'm not. What I need is, so this is, I just got appointed Mr. Salas, I want to say, very, very recently. I met him for the first time last week. This is our first time here. He's in a situation where the court only has two options, and one is to do nothing, the other is to put him in prison. And so, he's had a lot of family support reach out to me, and I don't have any family members here today. I would like for the court to at least hear from them. And so if the court gave me a brief reset, if you want to set it for a contested, that's fine. We're not going to contest the violations in the motion, but I need a little bit more time to gather his family support so the court can at least hear.
All right, so would you like to call it for next week?
It can be called for next week. I'm okay with that. Friday I will be flying out of the country, so.
Oh, no, it'd have to be before Friday.
Okay.
And if there's no objection from the state, if his family members want to appear by Zoom, they can as well.
No objection from the state. Thursday would be my best day.
All right, you want to do Thursday this week or Thursday next week?
Thursday next. Good.
All right, Norm, if you'll recall this for July 31st, please. All right, is there anything else, counsel?
No, ma'am.
Do you have any questions, sir? All right, thank you.
Thank you, Judge. Thank you.
You're welcome. All right, who is here on Eduardo Rene Rodriguez?
Mr. Rodriguez is not here.
All right, I think previously there was a motion for a bond forfeiture. Let me check.
So Mr. Rodriguez,
He has a previous bond.
he does,
forfeiture.
it was a compliance hearing. He's kind of had a history of, not knowing about these things. He bonded out yesterday. I was unaware of that. And I did not communicate with him to be here. I don't know if he was told that, but I can tell you that I have not spoken to Eduardo about coming to court today. So we're trying to get him right now, but he has proven very difficult to track down from an office perspective. I don't expect he'll be here today.
All right, this is what I'm going to do. Because you're unsure if he received notice,
I
right?
don't know. Probably not, knowing the jail, they didn't tell him that, they just spit him out.
All right, so
Fernandez?
I'll recall it for tomorrow.
Okay.
And he needs to be here exactly at 9. If he's not here, then a warrant will be issued. State
Yes.
on Mr. Eduardo Rene Rodriguez, there was a bond forfeiture issued, I'm sorry, judge's warrant issued for him because he didn't show up for a pretrial violation. So they released him from the jail. I guess somebody made his bond, which they should not have made, or the magistrate shouldn't have set a bond for him because I had issued a judge's warrant, but they did. And so defense counsel is telling me he was released this weekend. So he may not know he actually has court date today. So is there any objections to the court recalling it for tomorrow?
No, Judge, not from the state.
All right, so I'm going to recall this for tomorrow and he needs to be here at 9 a.m. All right, thank you.
I have one more, but I'll.
Sure. Which case?
It's Jason Martinez, Judge. He got crossed up with his, or he'll be here. He's not here, but he will be.
Okay, all right, thank you. Marcos Antonio Rios.
Present, Your Honor.
Hello.
Morning, Judge.
Good morning.
Judge, got two things for you. Today is our very first sitting on Mr. Rios. Additionally, I do have an agreed motion. The same that you have in your hand. For to convert the GPS tracking only so you can be allowed to work.
All right, we're gonna call 2025 CR 007-192 State versus Marcos Antonio Rios. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Michael DeLeon for Mr. Rios.
And are you Mr. Rios?
Yes, ma'am.
All right, so the first thing we'll take up is this motion. Defense has filed a motion requesting that conditions of bond be amended. State, have you had a chance to review the motion?
We have, Your Honor, and we've spoken with the family, and we are in agreement with defendant's motion to change it to tracking only and add a no contact order with any minor child.
We're agreeable with that.
All right, so you understand if you go to do any type of work in any type of home, that let's go off the record for a moment. To make sure that things are crafted so everyone is protected, okay? All right, thank you. Oh, Michael. Do y'all want to write it on here? This is
Yes.
the one I have.
Okay.
Court is calling 2025 CR 007-563 State versus Ronald Lamar Allen. Can I have parties announced?
Megan Galley for the state.
Charles Butcher for the accused.
And are you Ronald Lamar Allen?
I am.
Right, so before we take up any settings or discovery issues, counsel, you filed a motion requesting a reduction of bond.
That's correct, Judge.
All right, and what is the bond currently set at?
The bond is currently set at $100,000.
And state, are you in agreement to reduction?
No, Your Honor.
All right. And state, are you prepared to proceed on the motion?
Yes, Your Honor.
All right, defense, it is your motion. Do you have any witnesses?
Yes, Judge. I have Ms. Evelyn Allen is here. She's the mother of the accused.
All right, Miss Allen, if you'll come forward, please, and sir, if you'll stand near that computer. Yes. Can you raise your right hand for me, please? Do you solemnly swear upon the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. I need to make sure you keep your voice up because one, I need to hear you. And also the court reporter needs to hear you. Cindy, do you need her to wear the little microphone or no?
No, she's in front of the mic.
All right, if you'll state your name for the record, please.
Evelyn Allen.
All right, that's the right tone.
Oh,
for me to
good.
hear. Thank you. All right, defense, you may proceed.
Miss Allen, are you the mother of Ronald Lamar Allen?
Yes, I am.
And how long has Ronald lived in Bear County?
Over 8 years for sure.
And for the court, would you describe your relationship with your son?
We're very close. He lives with me, so he does help out around the house quite a bit. Like yard work, grocery shopping. We have a close relationship as far as sharing.
Now, Miss Allen, are you aware of any past instances where Ronald has failed to appear for the court?
No, not at all.
And under the circumstances of his custody battle, he's had to be in court a lot of times. Is that right?
Oh, yes.
And how long has his custody case been going on with the ex-wife or his ex-girlfriend?
Well, the trial is 8, so I would say close to 8 years old.
Now, are you aware of any past instances where Ronald has attempted to flee the jurisdiction or avoid any court proceedings?
No.
And if Ronald were released on a reduced bond, would he have a place to stay?
Yes,
And would you be willing to supervise or help monitor him if it was required by Judge Boyd?
yes.
And can you describe any of Ronald's involvement in his family or community prior to this arrest?
Ronnie is very light. In fact, one of the neighbors is here with us today that he's helped out. She's had health issues and he would bring her hot meals, take care of her yard. We in an elderly neighborhood, he's helped the elderly clean their gutter if they need to move heavy flower pots, whatever. He was well liked by all the neighbors in the neighborhood.
Now, Miss Allen, have you ever made any efforts to post Ronald's bond?
I've made several attempts. I've called about 5 bondsmen, and each one had different regular stipulations. Once was like I needed 4 signatures, co-signers, they called them, that had to have employment and live in Bear County, that would be responsible if in the event he would skip out for the $100,000. Plus a collateral of putting my home for collateral. And then another one required, I think, co-signers other than me, two co-signers, but other than myself or my husband at the time, be at peace.
Now,
And and collateral, whether it be like any my home or with 100,000, and I think the bonds, they started at 10,000, but said it could be up to the discretion of the manager of the bonds company. It could be more, but not less.
Miss Allen, do you believe a lower bond would allow your family to safely and responsibly secure the release of Mr. Allen, of your son?
It would be affordable, yes.
And what financial resources have you exhausted trying to help Ronald?
I'm embarrassed to say, but I've limited out all my credit cards and all my credit. Thank you. And I'm now that my husband's gone, that income is ceased, so it's it's very stressful and trying to find funds to.
Can you tell the court about your late husband, Ronald Wayne Allen?
Glad to. We were married in April for 52 years. We went to high school together. We had our class reunion, 55-year class reunion in September, which I'm glad we got to share that. And our anniversary, we're from Louisiana, so we got to share crawfish. And I'd like to say that for his final days, he enjoyed that, but it was a shock that he passed.
When did your husband pass away, Miss Allen?
June 13th.
And this was while your son was in the jail?
Yes.
And how did Ronald respond to the loss of his father while he was in jail?
Very stressful, very anxious. He just wanted to give me a hug and that support, be with the family. At first, I don't think he realized that he had passed because I couldn't tell him. And I don't think reality set in now. He's very, it's stressful. He says that he thinks of him a lot, trying to sleep, and that just needs to give me a big hug.
Miss Allen, has Ronald been able to attend any funeral services or grieve properly regarding your husband?
Your Honor, because I have 2 boys and myself, we're waiting for Ronnie to be able to attend the services before we can schedule them. We're from Louisiana, so our main service would be in Louisiana, Lafayette, Louisiana.
Miss Allen, from what you've observed, does Ronald struggle with any mental health concerns?
Very anxious, very stressful. the stress being in prison, has jail, how they call it.
And has he ever had any mental health conditions? Has he ever suffered from schizophrenia, bipolar disorder, or anything like that?
No.
And do you believe that Ronald would benefit from counseling or evaluation if released?
Oh, absolutely. He and I both to be able to grieve, learn how to grieve together, and get beyond this, because we need closure. And we need to share that bond. It's very hard for me. All alone at the house.
Now, Miss Allen, regarding these underlying charges, have you ever seen your son engage in anything violent or have any violent offenses, or has he ever lashed out at you in any way?
No.
And regarding these underlying charges, maybe you can tell the court a little bit about what these charges have meant to you substantially.
Trying to understand the charges. At first I said, this doesn't sound like my son. But again, he can get excited, he can get anxious. He was struggling with the custody. And the process that was going on. And he can get excited, and we're from Louisiana, so he may raise his voice, but as far as he wouldn't even hurt himself. I mean, he's very, very controlled person. He's very low key. I've never seen him ever say anything to harm anyone. And I'm gonna bring in the custody was for his child that he loves very much. He's a very good father. They've always enjoyed very good times together. And so this was very trying and distressful for him. And trying to communicate with him about the loss of his dad and my grief, it's hard on the privacy of a phone for minutes at a time.
Miss Allen, I want to thank you for your testimony, and again, I'm sorry for your loss regarding all of this and the stress that you've been under the last 90 days while he's been in jail. I'd like to pass the witness now, Judge.
Any questions?
Miss Allen, just briefly, I have a couple of questions for
I'm
you.
sorry.
I said, just briefly, I have a couple of questions for you, okay?
Okay.
You stated that your son moved to Bexar County about 8 years ago.
Yes, I mean, he's been in Bexar County as long as his child's been born.
Okay, do you know where he was living before that?
I can't, when they were married, they lived in, Wimberley?
Okay, Wimberley, Texas?
Yes,
And then, before that, did he live in Louisiana with you and your husband?
I've been in Texas for 52 years.
Okay, so at any point, did your son live in Louisiana or no?
He may have stayed there to help a family member. His grandmother had eye surgery at one point, and his uncle lived, well, that's Texas, so, just with his grandmother years and years, I mean, maybe 30 years ago, but when she had, but he never had a residence. He
Okay,
was
just
helping
staying there.
caregiver.
Okay,
Yeah.
all right, thank you. And then are you currently working right now or are you retired?
I'm retired,
Okay, how long have you been retired?
21 years.
Okay, do you receive like retirement from the government?
No,
Okay. Do you have like a 401k or any retirement from your job?
I have a retirement, but I don't survive on it. I
Okay,
survive on Social Security.
so about how much income do you get monthly?
I don't remember, but I think it's like, 1,500 or 1,600 a month.
And before your son's arrest, was he employed? Okay, what was he doing for work?
He was like, what I understand, courier, like delivery.
Okay, was he employed with like a company or self-employed? Do you know?
I think he mentioned, I didn't get too much into his business, but, like a self-contract or contract.
Okay, and do you know what his like hourly rate was or monthly rate?
No, I didn't get into that.
Okay, do you know if he has any savings accounts?
I can't answer. I don't know.
Okay, you guys haven't discussed that in your efforts to make his bond? If he has money saved up to assist you?
When we talk on the phone in the prison, we try to keep everything, generic for the private thing.
Okay.
And I get into financials to keep it private. So if. Fine.
Okay, but you would agree with me if he had some type of money or savings, that would help you try to make his bond, right? That would assist you in your efforts.
Yeah.
And then as far as your home, you said you've lived here for 52 years, so do you own your home currently or are you renting? You own it? Okay, and do you have a vehicle that you own?
Yes.
Okay, and what about your son? Did he have a vehicle that he owns?
No.
No? And what about a home? Did he have a home that he owned prior to this?
No.
Are you aware of any of your son's prior arrests?
When he had his divorce.
Okay, would that be around 2015? Have you heard that he was arrested for assault, family, house, impeding breath or circulation?
Is that again? I'm sorry.
Were you aware that in 2015 he was arrested for a family violence assault, including strangulation?
I was aware that he had a legal issue with his divorce. Yeah.
Okay. And then before that, in the year 2000, were you aware that he was arrested for possession of marijuana between 5 pounds and 8 pounds?
I believe that I had not.
You did? Okay. And then were you aware that in the year 2016 or 2015 that he was arrested for unlawful restraint? In 2015. Okay. And were you aware that in 2016 he was arrested for assault, bodily injury against a family member?
In what year?
2016.
No.
We passed the witness, Your Honor.
Any further questions?
Yes, I'll take short redirect. So, Ms. Allen, you are aware that your son has had some violent instances, allegations. Where were these allegations regarding the family violence assault coming from? Like, who do you think is actually made these allegations against your son, Ronald?
The one that I said I was aware of would be the ex-wife.
And have any of these allegations and any of these charges in the past, have they resulted in Ronald going to jail or having a conviction?
Not that I'm aware of, no.
So he's never been in jail for this long for any of these alleged assaults from the past?
No.
And most of these are from over 10 years ago, or at least 10 years ago?
Yes.
And on the marijuana charge, that was in 2000, in the year 2000. He was a young man at that time, right?
Many years ago, yes.
And you were aware of that?
Yes.
In light of all of these items and these matters, has Ronald ever been violent towards you?
No.
Do you have an ability to supervise Ronald if he's released on bond and put under your supervision?
No.
All I have, Your Honor, regarding this witness.
All right, any further questions?
No, Judge.
Any objections to the court asking a question?
No, Judge.
All right. So in your home, are there any weapons? No guns?
No, ma'am.
And if your son were to make bond, he would be staying with you?
Yes, ma'am.
And is that in Bear County?
Yes, ma'am.
All right. Any other questions from either side?
No, Judge.
Any
No,
other
Judge.
questions with this witness? I'm sorry for your loss. It is so rare to see people who are high school sweethearts get married and that it lasts for that length of time. All right, thank you so much for coming in.
Thank you very much.
You're welcome. All right, call your next witness.
That's the only witness I have for today, Your Honor.
All right, state any witnesses.
No witnesses, but the state would offer states exhibits A and B for the purposes of this hearing. Which is a copy of the prosecution guide and the criminal history of the defendant.
Any objections to the court reviewing?
No objections to that.
Okay, just give me a moment to review. All right, the court will hear argument.
Judge, in addition to all of this, I do have a copy of Ronald's father, Ronald Wayne Allen's death certificate, so that we know that this is an honest
Oh, no,
regarding this man. He was an Army veteran and.
all right, and I reviewed the document, and counsel, you're an officer of the court.
All right, thank you,
Thank you.
Judge. Regarding this matter, Your Honor, we're here today on this motion to reduce bond filed on behalf of Ronald Allen. Mr. Allen is currently sitting in the custody under conditions that neither reflect his flight risk nor serve the purpose of public safety. We think that this incarceration, in fact, functions as an instrument of oppression prohibited under the Texas laws and the United States Constitution. Under the Article 17.15 of the Code of Criminal Procedure, the court must consider the following factors. The bond must be sufficiently high to ensure appearance. It may not be used as an instrument of oppression. The nature and circumstances of the offense must be considered. The accused's ability to make bail must be regarded, and the future safety of the community and any alleged victim must be weighed. Further, Article 1.07 guarantees that bail is a right, and Article 17.09 permits this court to modify bail at any time prior to his conviction. The Eighth Amendment of the U.S. Constitution prohibits excessive bail, and the 14th Amendment's due process clause requires this court to avoid pretrial detention solely on the basis of poverty. The application to this case is that there's been no physical confrontation and no victim impact regarding this case. The underlying facts of the case would show that Mr. Allen was in a private conference with his custody lawyer at the time of the alleged offense. We want the court to understand that this was an emotionally charged conversation because of a long custody and visitation battle with his ex-wife. And his family attorney had only been retained for several weeks. The statement that he made that gave rise to the terroristic threat charge was made outside the presence of any alleged victim, and there is no indication that Mr. Allen took action to carry out any of his threat. The case was documented by the San Antonio Police Department and the Fusion Center, but it resulted only in an information report, not an arrest at the time. No firearm, no plan, no attempt, just words spoken in the distress amid his ongoing family court litigation and the emotional duress. Notably, the complainant himself, the attorney that he had, called the SAPD out of an abundance of caution, but he was not in fear. The compelling personal circumstances on this case are substantial because of in addition to the low risk nature of the alleged offense, Mr. Allen has experienced profound personal hardship because his father, Ronald Wayne Allen, passed away while Mr. Allen was incarcerated. He has been unable to grieve properly or to attend final arrangements. Family tragedy only worsens the financial burden of a high bond. We think that Mr. Allen needs help to grieve, to deal with these charges. It would also help for him to be able to manage his defense. You heard today from Evelyn Allen. She's the defendant's mother. She's a woman of modest means who has established her financial resources through her marriage with her husband, who recently passed. She's exhausting her financial resources trying to help her son, and she has testified that Mr. Allen has longstanding ties with the community, has never failed to appear for court, and she is willing to supervise him personally, and that the current bond amount is financially oppressive to their family. Your Honor, we are not asking the court to ignore the concerns of public safety, only to apply the law fairly. There's been no evidence that Mr. Allen poses a threat to any person if released. He does maintain there is a civil protective order between him and his prior lawyer, because he's the one that made the report and the outcry regarding the terroristic threat. But he would abide by that protective order substantially. There is, however, evidence that the current bond amount is far beyond his means and his family's means, and we believe that it's unnecessary to secure his return to court. We are requesting at this time that the court consider reducing Mr. Allen's bond to a reasonable amount or releasing him on appropriate pretrial conditions, which may include GPS monitoring, counseling, or any mental health evaluation if the court deems such conditions necessary. We believe that this would align with the Code of Criminal Procedure, Article 17.15, as well as the constitutional safeguards designed to protect the rights of the accused while preserving public safety. From where I'm sitting, I recently became his second criminal defense lawyer, and it is a difficulty for me to prepare for a complicated, what's likely a complicated trial regarding this case. I've filed motions to suppress and a motion to dismiss this charge, but I'm not here on that today. I'd like to get my client released under a reasonable bond so that I can prepare and have him prepared for those hearings outside of the jail.
All right, State.
Judge, we believe that the bond has been set in a sufficient amount regarding public safety. Regarding the testimony that you heard from today, it sounds like, well, the mother does have limited needs. She does have several items of collateral available to her, and there's also this untapped resource and the defendant's own personal belongings, financial resources, and bank accounts that they've neglected to speak about for privacy reasons, as testified to by her. And then regarding just the flight risk, I mean, he does have ties to locally Texas and Louisiana. So we would ask that you keep the bond amount at 100,000.
Judge, I guess if I may, with respect to the family resources, they are, she doesn't have a lot of access to a lot of the funds that might be available in their normal circumstances if Ronald's father was alive. Just weeks after Ronald was incarcerated or jailed, this man died. And so we believe, and Ms. Allen has advised me, that a number of those resources and properties are going to be tied up in probate in the coming weeks.
Well, let me just explain something. I don't believe that someone should be required to put their home up for collateral to make somebody else's bond. So I'll just lay that there. That is gambling to put your home up.
Yes.
Because the bondsman will take your mother's home if you fail to appear.
Mhm.
So this is the court's issue. So I've read defense, I've read your motion. And in your motion, you put that Judge Hortek found that your client wasn't a threat to his son or the community at large, and that there will be a protective order regarding his ex-wife,
Yes, there is, Judge.
and that he will be allowed to proceed with his visitation rights. So I don't understand. On the civil side, they said he was going to have his visitation rights. It's going to be supervised, and they wanted a psychological evaluation. I don't understand how we go from that to now he's before me on a charge of terroristic threat. And Mr. Allen, I want you to know, I don't take any of this as true because I haven't heard any evidence on the facts. The reason why I bring that up is because, as you stated, counsel, part of the things I consider in a bond reduction is safety of the community. So in this case, safety of the community would be based upon the indictment, the community at large, and also the protective order that your ex-wife has, her safety as an individual, but then the community at large, based upon the exhibits that the state had me read, which was part of the police reports. So that's the court's concern.
Well, Judge,
And has he done a psychological evaluation? Has that been done or was that completed?
no, Judge, the order coming from the civil case, from my understanding, I'm not a civil lawyer,
Mhm.
but my understanding is that that final order in that SAPSER modification that was filed by the ex-wife and was litigated while he was in jail through Judge Forte, that is pending as far as the order being signed.
Okay.
There are judge's notes that indicate what I mentioned in my motion, that the protective order against the son was denied. There is, I think there's other ways to secure the community other than a $100,000 bond. I think a GPS or any kind of tracking would be able to secure compliance. And if there's a bond condition that prohibits his contact with either the complaining witness in the underlying terroristic threat case, or who I believe did get his own protective order, and then also a protective order, or rather a bond condition that prohibits his contact with the ex-wife, and ask him to remain in the jurisdiction. I think that can mitigate some of the risks of him not coming to court.
All right. And state?
I would just reiterate my prior arguments and then the testimony regarding his prior arrest.
All right, this is what the court is going to do. With regards to your other motions that you filed, the motion to dismiss and the motion to suppress, we'll set those for hearings and y'all confer. And I would like those hearings set as quickly as possible because that may end up addressing whatever issues are here. But Mr. Allen, I'm going to deny the motion to reduce bond. I'm going to order that there be partial GPS for employment only. GPS fees will be waived and there'll be a referral to Center for Healthcare Services. So if y'all would confer with Ms. Ferguson on having that motion to suppress heard counsel and also your motion to dismiss. And so if y'all speak to her, she'll tell me what's the date that y'all both can agree on, and we'll make sure that hearing is heard.
Thank you, Judge.
All right, you're welcome. Thank you, counsel. And just come back to me once you get a date. Yes. State. Megan?
Yes.
Norma is telling me that his next court date is July 28th. Would you all be ready? All right, so counsel, if the state needs to have witnesses by Zoom, are you okay with witnesses appearing by Zoom or you want them all in person?
I don't have any objections to witnesses appearing by Zoom.
All right, so defense said if need be, some can appear by Zoom. All right, so we'll put you down for next week, Mr. Allen, and if the state is able to have their witnesses sooner than Monday, they'll let defense counsel know, and we'll have you brought over sooner, all right?
Okay.
All right, thank you, sir. All right, could I see Mr. Renteria, please? If you'll come down. Hello.
Hello, good morning.
Good morning. All right, so your attorney is still in legislative session. I guess they've had a special session or they extended it. So this is going to be recalled. Number recall this for August 11th. All right, thank you. Marcos, Antonio Rios, are y'all ready?
Yes, Judge.
All right, we're gonna go back on the record in 2025 CR 0071192. State versus Marco Antonio Rios. Could I have parties announced?
Rick Pena for the state of Texas.
Michael DeLeon for Mr. Rios. Judge, we've discovered, Mr. Rios has been a plumber for 8 years. He does mostly commercial work. Very rare that he ever does residential, but we put a provision in there which will hopefully take care of any concerns the court might have.
All right, so the agreement that you all have reached does address the concerns of the court. So it will be GPS tracking as agreed to by the state. There's to be no contact with any minor child. And there's to be a co-worker present with you if you're in any residence. And a supervisor will send notice that this order has been followed every week to pretrial services. Do you understand?
I understand.
So what that means is if you're working in a residence and for some reason, because I know with plumbers, sometimes someone will have to go to the truck to get a tool or something of that nature, you're going to need to be the person to go get a tool from the truck. Otherwise, you need to accompany them to get whatever tools. Do you understand?
I understand.
All right. Now, the next thing we need to address, council, I have signed that motion.
Judge, this is our very first appearance. I've reviewed the state's file. There's gonna be some discovery I need to look into, including their CPS records on a CD and some additional same records and of course the counseling recording.
All right. State, do you have the CPS records in your custody?
You should be right there in the.
It appears we might, so we probably just need to burn a copy for him.
All right. All right, Norma, I need a 45-day reset for discovery, please.
Judge was supposed to be in Live Oak County on September 11th.
All right. That's not a good date for council.
Yeah, I'm supposed to be in Atascosa County on the 9th. Yes. That can be September 8th.
All right, we'll have you back on September 8th. And council, I'll put this in the system. And then you'll need to make a copy of the order if you need a copy of the order.
Okay, Judge, sounds good.
Just give me one moment. And thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
I appreciate that, Your Honor.
You're welcome.
Thank you, Judge.
All right, Matthew and Seriaga. All right.
Good.
Good morning. How are you doing?
Good. How you doing?
Oh, I'm doing okay. So have you conferred with the state?
I have not, Judge. He was magistrated and no bond was ever set.
All right, if you want to speak to the state on an amount of bond, and then I'll bring you all back up.
Okay, here's my.
All right, thank you. Crystal Veloz. All right, this is a long indictment.
It is, it has actual checks in it.
Yes.
Federal.
All right, so where are we on discovery?
So I just learned about some additional discovery that the state has. This is essentially a white collar case.
Mhm.
There's a lot of discovery to go through. Additionally, it's essentially a restitution case, so my client is going to try to get as much money together as he can in hopes of achieving a more reasonable offer from the state. So I'd like to ask the court for maybe a longer reset.
All right, Ms. Ferguson, if you can set this for a 45-day reset for discovery.
September 8th, would work. You wouldn't give to me a little bit longer than a few months?
No. All right, so September 8th or 11th, council.
8th.
All right, we'll come back on the 8th for discovery. State you'll need to make sure that they have all of the discovery.
Absolutely, Judge.
All right, thank you, thank you. Once you sign the reset form, you're excused. Jason Martinez. All right. Let me find you on the docket. Thank you. So council, where are we on discovery?
I think we're good on discovery, Judge.
Okay. Was state able to tender an offer?
They are, Judge. We're gonna be submitting an application this week, probably today, for a pretrial release. I anticipate it will likely get approved, so just kind of let you know where we're going.
All right, Ms. Ferguson, can I have a PTD date, please? All right, so it's gonna be August 19th.
August 19th.
All right, so I allowed your counsel to have some time to make sure that you show up, but court is at 9 a.m., all right? All right, and I don't want you to answer me, but if you're drug tested today, is everything gonna be okay? I have a feeling I know what the answer will be. So for his conditions of bond, does he have any conditions?
I admittedly do not know the answer to that.
All right,
Probably
not.
well,
It's probably not based upon the case. So are you employed?
Right now, no.
All right, so you need to start looking for employment, you understand?
I'm already in
All
the
right.
market right now.
Okay.
So,
How old are you?
me, 22.
All right. Do you live with someone?
Yeah, I live with my mom. Well, in the beginning of the year, I didn't have a job because I broke my foot in the beginning of the year.
How did you break your foot?
Work,
Oh, so at the beginning of the year, what type of work were you doing?
construction, like site work, like
Mhm.
heavy machinery and stuff.
Oh. Well, who knows? Maybe you need to speak to an attorney.
he was playing for the Spurs, Jack.
Okay, I like that. But see, now I'm about to ask him the $1,000,000 question. What position were you playing for the Spurs?
I was playing center.
I like
Was
that.
that small guard, but no, I'm sorry.
All right, so I'm gonna add an addition to his bond. And I'm gonna require that he do sober support meetings. And so you're gonna have to do 30 of those in 30 days. And it's to make sure that you maintain sobriety, you understand? And your attorney will explain to you what that is. And we will see you back on the 19th.
August 19th.
Yes.
Thank
Yes, you're welcome.
Thank you, Judge.
Thank you. Haley Joe Vatter. Hello,
Hello, ma'am.
how are you doing today?
I'm doing all right. How about you?
Oh, I'm doing great. I cannot complain. All right, so on this case, counsel, do you have all discovery?
I have a request pending, Judge, but I
Yes.
haven't received everything yet. And then I think we're still pending some discovery because the state wants to reach out to CW for receipts for restitution.
Okay.
She has this indicted case and then a pre-indicted case, so the state wanted more time to reach out to both victims.
Judge, and just so the court is aware, she does have an unindicted case that I'm reaching out to tender a global offer to defense.
All right. So when would you all like this case recalled? How much time does everyone need?
The state told me they would be okay with maybe 2 weeks.
All right, Ms. Ferguson, if you can recall this for 2 weeks. And Miss, has your client had any type of mental health issues?
I believe so.
All right, is there going to be any issue with that or competency? She's like, no.
I'm not entirely sure.
I am also not entirely sure, but I'm going to do another jail visit with her to review her discovery with her.
Okay.
And then I think after that, I will be able to proceed the rest.
All right. All right, what date? And who is Leo?
That would actually be a zodiac sign, ma'am, and that
That's what I was thinking.
about 5 of my family members.
Okay,
My daughter, my son, my brother, well, he's not a family member, a close friend, and my nephew.
okay, all righty then. All right, so we're gonna see you back on August 4th. And if anybody wants you brought back sooner, they will let the court know, all right? Do you have any questions for me?
I don't believe so.
All right, thank you.
Thank you.
Do you need a cough drop?
Okay, thank you.
All right, thanks. Who is here on Procuro Daniel Rodriguez Luna Jr.? All right, so sir, you need to be here at 9 a.m. Right?
When was it?
9 a.m. for court.
Today.
If you're not here at 9 a.m., you're late and a warrant may be issued. You understand? All right, So where are we on his PTD?
Just got him to sign it, Your Honor. I'll submit it to him. They accept it pretty fast.
All right, so why is it just being done today? Because we were here on June 13th for a PTD.
I had trouble communicating with my client and also outside of town on some of those days.
All right, so that needs to be filed today.
I'll do it today, Your Honor, and if you want, we can recall it for next week if you want. They're pretty fast at accepting it.
All right, Ms. Ferguson, I need a date for PTD. And do this one quicker than normal. Set this one sooner than normal. All right, so we will be back on August 4th. Once you sign the reset form, you'll be excused. Thank you. If you just have a seat, your attorney will bring the reset form to you, sir. All right, and Devin Berry? You need to call your attorney. You need to call your attorney for your attorney to be here. Thank you. David Sains, are you ready to proceed with the motion?
No, Your Honor, it's gonna be a contested motion.
Oh, let's see here. All right. So state, will you prepared in 14 days for a contested?
We will be, yes, Judge.
All right, Ms. Ferguson, I need a 14-day reset for contested hearing. And it is on David Sains. August 4th. All right, we'll see you then.
Thank you, Your Honor.
You're welcome. Bashan Sains is set for a contested hearing on August 4th. Who's here on Jose Giannis?
Butcher for the defendant.
All right, Mr. Giannis, if you'll come forward. All right, have you conferred with the state?
Yes, Judge, I did.
Let me just find him on the docket. Thank you. All right, counsel on Mr. Giannis, do you have all discovery?
I don't have all the discovery, Judge.
All right, what is missing?
I'm missing a video and I think it's just a download problem that I have because it's substantial amount. I just came onto this case and it was set for an arraignment today. This is his first arraignment. He's made bond. I conferred with the state and they have made some offer, but we want to review the discovery. And the state has told me that they're not opposed to a short reset so that I can.
All right, state.
Yes.
Defense counsel is saying there's an issue with the download on the video because I guess it's too large. Has that been addressed or how is that going to be addressed?
But we should bring these at this drive when we got.
Sure.
All right, Ms. Ferguson. If I can have a reset date for 30 days for discovery. So between now and then, you'll need to provide the disc.
Yes, Judge, I recognize it's an old case. This is from 2022. I want to get it resolved too, but here we are.
All right, what date? August 19th would be your discovery date. All right, thank you for addressing appropriately for court. Just have a seat. Once you sign the reset form, you'll be excused and counsel, you get your reset form. Thank you.
Sorry, guys.
All right, if you'll come up, please. Thank you for your patience, Mr. Woodard, although you're always patient. I appreciate that.
No worries, Judge.
All right. Court is calling 2025 CR 00792 State versus Matthew Insuriaga. Could I have parties announced for the record, please?
Ashley Jones for the state.
David Andre Woodard from Matthew.
And are you Mr. Insuriaga?
Yes, ma'am.
Insuriaga.
Insuriaga.
All right. All right. Defense has filed a motion asking that a bond be set. According to law, he's entitled to a bond. The only issue will be what the bond will be set at.
Yes, ma'am.
All right. Have parties had a chance to confer on a bond amount?
Yeah, Judge.
We have your honor.
Is there any agreement?
Yes, not Judge.
All right. Defense, do you have any witnesses?
No, you
All right, then the court will hear arguments. State unless you have witnesses.
We do not, Your Honor. If the court would like, if you can give me one moment, I will print out the prosecution guide for you.
All right. And for the record, the court is aware of the charges. And defense, what bond amount are you requesting?
$50,000, sir.
And-
Yes, with partial house arrest.
And state what bond amount are you asking for?
The state is asking for 100,000 full house arrest GPS and a no contact order with the complainant or any minor child. And the state would also like to enter an exhibit. If you're gonna work, state's exhibit 1.
All right. While the state is doing that, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you speak up so the court reporter can hear and I can hear. If you'll state your name for the record.
Matthew Insuriaga.
All right, so the questions I'm going to be asking you are questions related to bond conditions. So I'm not going to ask you about any facts of this case. Do you understand? All right, number one, if you are able to make bond, who would you be living with?
A close friend of mine.
All right. And this close friend of yours, do they live in Bear County?
Yes, ma'am.
Are there any minors in that household?
Yes, ma'am.
That's not going to be allowed. So do you have any other place to stay?
Yes, I was just had to talk to. I need to talk to you.
So what I can tell you is I'm not going to allow you to reside in any household where there are minors. I don't take these allegations as true because that's not what we're here for today. It's just a matter of setting bond. And as in setting bond, I have to make sure that the community is protected. Do you understand? So do you have any employment before you were taken into custody?
No, ma'am.
All right. Have you ever in the past used any type of drugs or alcohol?
No, ma'am.
No marijuana, nothing?
I just smoked like a year or two ago. That's about it.
All right, so when I ask these questions, I need to know the full picture, all right?
Yes, ma'am.
Have you ever received any type of treatment for mental health issues?
No, ma'am.
Have you ever been on type of any mental health medications?
No, ma'am.
All right. Any other questions, defense?
No, Your Honor.
Okay. So state you're presenting to the court for review the police report?
We are, Your Honor. It's a prosecution guide. And the state would also note that the defendant does have. I apologize, Your Honor. Odyssey is giving me a little bit of trouble.
All right. Here, state.
Thank you, Judge.
All right, this is what the court is going to do. The court is going to set your bond at $60,000. There's to be full GPS, waive fees. There's to be no contact and no residing with minors. This is what I can tell you, counsel. If he's employed and if he provides proof of employment to the court, then the court can always consider lifting the full GPS.
Thank you, Your Honor.
Is there anything else with regards to the bond? Any other conditions that are being requested by either party?
Just no contact with other minors, Your Honor.
Yes, I said no contact with minors.
Yes, Judge.
Oh, no problem.
Not from the defense, Judge. Thank you.
And Mr. Insuriaga,
Yes, ma'am.
I want you to know that I understand when I say no contact with minors, that means no residing with minors as well. But so there's no confusion, I always have to put it in both places. Otherwise, the court may receive an email from pretrial services saying, well, you know, the minor doesn't have contact with him because the minor is on the property or something of that nature. Or you're just on the property living in the back. So you can understand you're not to reside in any household where there are minors. So I know sometimes people will have a home and they have a guest home. If there's a minor who lives in that home and you're living in the back, you're not allowed to reside at that location. Do you understand?
No.
Is there anything about my ruling that you don't understand? All right, so where are we on discovery?
Judge, I was just appointed to this case on July 14th,
Okay,
so I haven't received discovery yet. I haven't conferred with the state yet.
all right, Ms. Ferguson, if I can get a reset date for 45 days for discovery, please.
I think either should be fine, Judge.
All right, so which do you prefer?
Assuming the 8th.
All right, don't make us make that decision. All right, September 8th. All right, is there anything else?
Not from the state judge.
All right, thank you. You're welcome. Wilfredo Mati.
Morning, Your Honor.
Good morning. All right, this isn't the, is this,
This is the same case that we had on Friday.
all right,
I recapitulate a little bit what happened. Yeah, so
Sure.
he got probation on clause number 2025 CR 002719. After he had pled, but before he was sentenced, they filed an indictment which was coming out of the same fact pattern, theft case, which is 2025 CR 007197. So I've conferred, and I believe that they are willing to TIC that case if they could add conditions to his probation for any possible restitution that would have arisen out of that case.
okay. So let me pull up the other case. And that's 2025 CR 0027.
002719. That's the one that he pled on, that you gave him probation. No, excuse me.
That's this case.
Yeah, 7197. That's the one that was indicted. He's before the court. The one he got
Yes.
probation on was 2719.
9, all right. So what are you all requesting?
If the state had known about this case, it probably, everything would have been resolved.
Mhm.
So in order to move forward with the TIC, have probationer go on probation, which is what the court parties were wanting, we would want to amend and alter conditions to reflect what would have been done at that hearing had we known about this case. And so if we're able to add conditions to the case for which probationer was granted probation that reflect items for this theft case we want a TIC, then we would be able to resolve everything today.
Okay, Yaya, can you have them bring out this file for me? 2025 CR 002719. All right, so do you understand what's happening?
Yes, ma'am.
And are you in agreement to that?
Yes.
All right, we'll go on the record. The court is, and Ms. Abrams, this is a motion to revoke. Well, not a motion to revoke, it's an amendment of his probation. It is Wilfredo Mati, Mattei. All right, the court is calling 2025 CR 002719 State versus Wilfredo Mati. Can I have parties announce?
Duffy Pitlock for the state of Texas, Your Honor.
Brian Kimbrough for Mr. Matei.
And are you Mr. Matei?
Yes, ma'am.
All right, and I'm so sorry, I forget. Is it Matei or Matai?
Okay.
Matei. All right, Mr. Matei, you're currently on probation out of this court. And both parties off the record have informed the court that this new case appeared. It's 2025 CR 007197. And both parties have agreed that the state would take this case into consideration and add conditions to your probation and cause number 2025 CR 002719 to include any restitution amount that's owed to the complainant in 2025 CR 007197. And the complainant in that case would be U-Haul. Did you understand?
Yes, Your Honor.
And is that the agreement from the state and the defense?
In addition to restitution, the state would be asking for no contact.
All right, and also no contact with U-Haul.
Is that every U-Haul
Yes,
in America or in Texas?
that's every U-Haul. So you're gonna have to do it the way we did before there was a U-Haul. You call your friends, you see who has a truck, right? And that's what we would do in the past.
No U-Hauls.
Okay. All right, so is that the defense and states agreement?
Yes, Your Honor.
That is, Your Honor.
All right, Mr. Matei, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Wilfredo Matei.
All right, Mr. Matei, did you understand the agreement that's been reached between yourself and the state?
Your Honor.
And are you in agreement to that?
Yes.
And you understand in cause number 2025 CR 007197, you have a right to a jury trial if you so wish?
Yes, Your Honor.
And do you wish to have a jury trial in that case or no?
No.
All right. So then the court will accept the dismissal from the state without objection.
No objection.
And as previously stated, your conditions and cause number 2025 CR 002719 will be altered and amended to include restitution, if any, to U-Haul, and cause number 2025 CR 007197, and there's to be no contact with U-Haul. Is there anything else from either side?
Nothing further, Your Honor.
Not from the state, but if the state may tender.
Thank you. And probation will go over your conditions with you. And we're off the record. Counsel, do you need a setting for a restitution hearing with regards to that? All right, thank you.
Thank you.
Thank you.
All right, so who is here on Raul Fernandez? Oh,
Your Honor.
Yeah, that's the one that is on probation.
Court is calling 2021 CR 11807 State versus Raul Jacob Fernandez III. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Peter Calderola standing in for Gail Calderola for Mr. Fernandez, Your Honor.
Are you Mr. Fernandez?
Yes, ma'am.
Do you have any objections to this attorney standing in?
Just made a mistake and
No. Any objections?
I mean, if you have.
No, ma'am, no, ma'am, no, ma'am.
All right. Did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Raul Jacob Fernandez III? Guys, we're on the record. Who was placed on community supervision in 2021 CR 11807 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on February 15th, 2022 for a term of 4 years. Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bexar County, Texas, the defendant Raul Jacob Fernandez III did then and there fail to report to the supervision officer as directed for the months of March through December 2022 in violation of condition number 4.
All right, to that, how do you plead? True or not true?
The state will waive and abandon the remaining violations, Your Honor.
No objection, Your Honor.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 4 years in the prison
Yes, ma'am.
and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
No.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Your Honor, we don't have an agreement, but we have proposals.
All right, state, what are you requesting?
We are requesting that you grant the state's motion, revoke probationer, sentence probationer. The state recognizes you have 4 years. State is asking for 3. The state will tender TICs for 2 new number 1s at the resolution of this matter.
And Judge, that we're following that proposal.
Oh, you all in agreement to the 3 years?
Yes.
Yes, Judge.
All right, sir, are you waiving your right to appeal?
Yes, ma'am.
And are you asking the court to follow this agreement?
Yes, ma'am.
And what cases are being taken in consideration?
possession of a controlled substance.
The cost numbers.
Oh,
if you
sorry,
have
Your
them.
Honor.
That's okay.
Yes, we have 2025 PF 23502.
Mhm.
And the second one, 2025 PF 23503.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed. Oh, I'm so sorry. Just one moment. The court is going to grant the motion, find violation of condition number 4 true, revoke, sentence you to 3 years in the prison, give you credit for any time served, take in consideration 2025 PF 23502, 2025 PF 23503, and the court will request the therapeutic community. All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So why were you not successful?
I just messed up, ma'am. Sorry.
No, I understand that sometimes things happen, right?
No.
So here's the thing. It appears to the court that you may have a drug issue. You need to make sure that you take care of that. You'll request the therapeutic community. I have no jurisdiction to have them force you into the program or order them for you to be in the program. But if you don't ask for it, they definitely will not put you on the program. Once you're released from prison, if you can't find a sober support home or somewhere to stay or help with your addiction, you can come back to court. If I'm still here, I'll get you the help. You understand?
Yes, ma'am. Thank you.
Because the last time you use may be the last time you use, and only 2 things are going to end up happening in your situation. Either you're going to end up in and out of prison or in and out of jail, or either it may be the last time you use. You understand?
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
You're welcome.
Thank you, Judge. Are you
Thank you.
excused?
Yes. Who's here on Christopher Shad?
Christina Shaw.
Christina Shad?
Yep, Judge.
All right, thank you.
Shaw, come on in.
All right, the court is calling 2025 CR 007106 State versus Christina Louise Shad. Is that how you pronounce your last?
Yeah.
All right, that party's announced.
Duffy Pitlock for the state of Texas, Your Honor.
Jay Moritz, Your Honor, from the Shaw.
And are you Ms. Shad?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Shad, did you review the indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Shaw, did you review the court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
I'm sorry, is the court admonishments
It's this document. It tells you everything, what you're charged with, and it tells you the range of punishment, and it tells you what your rights are.
Okay.
Did you review that with him?
Yes.
And did you understand it?
Yes.
And did you sign it in all the appropriate places?
Yes.
All right, so you're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from a $10,000 fine and anywhere from 180 days up to 2 years in the state jail facility. If you have a plea with your attorney and with the state, the court does not have to follow that agreement. If for any reason the court does not follow that agreement and give you more than you bargained for, the fact that you entered a plea will not be used against you, and we can start over. Do you understand?
Mhm.
And you can withdraw your plea. Do you understand?
Yeah.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Hmm.
Did you understand that?
Yes. Yeah.
Did you understand by entering this agreement, you're giving up those rights?
And
You understand that you're giving up the rights to a trial by jury?
yeah.
All right, so I'm gonna take it step by step. And has she been before me before? Why do I remember her?
No, the first time she had some cases years ago where she was ruled incompetent.
Okay. All right, so you have a right to a jury trial. Do you understand?
Yes.
All right, so what that means is 12 people would sit on a jury. 12 people, neither you or the state knew beforehand. And the state would call witnesses. Do you understand?
Mhm.
You're gonna have to say yes or no.
Yes, ma'am.
Right. And the state would call their witnesses. And then your attorney would be able to ask them questions, or you could ask them questions. Do you understand?
Yes.
All right, so because you're entering this plea bargain agreement, the state is not going to call any witnesses, and your attorney is not going to have a chance to question any witnesses, and you won't be able to question any witnesses. Do you understand?
Yes.
All right, do you understand that if the state were to call witnesses, the state couldn't say, I'm going to call Ms. Schott as a witness. So do you understand that?
Yes.
So you're giving up your right to remain silent also by entering into this plea bargain agreement that you've reached. Do you understand?
Yes.
So do you want a jury trial? Yes or no?
No.
All right. Counsel, has your client been able to provide you with any defenses?
Yes, Judge, I've had a Zoom with her at the jail and we discussed things.
Do you believe she has a rational, a factual understanding of the charges against her?
In my opinion, at this time, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Judge.
Ms. Schott, has anyone threatened you, forced you, or coerced you to get you to enter this plea?
No.
Anyone promise you anything other than the plea bargain agreement that you've worked out?
No.
Are you satisfied with the way you've been represented?
Yeah.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
All right, so this is what I'm being told your plea bargain agreement is. It's 180 days in the state jail facility. You're not applying for any type of probation. And there's to be $60 to be paid to the Bexar County Laboratory. Did you understand that?
Yes.
And that $60 is what they say it costs for them to do the drug testing. Did you understand that to be your plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, it is, Judge.
Did you review the waiver of appeal paragraph with your attorney?
Yes.
Did you sign it in both places?
Yes.
All right. So by signing that, if I follow this plea bargain agreement, you can't come back later and appeal that. Do you understand?
Yes.
The only rights you have to appeal is if your attorney has filed pretrial motions, such like maybe a motion to suppress or something like that. And I've made a ruling on that. Do you understand?
Yes.
Counsel, have there been any motions that you filed where the court has made a ruling on them?
No, Your Honor.
All right. Then to the charge, how are you going to plead? Guilty, not guilty, or no contest?
No contest.
All right. State, any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
No objections, Your Honor.
Thank you. All right, did you review the stipulations and waivers with your attorney? That is, it consists of police reports, the reports from the chemist on whether or not the drugs tested positive for any type of drug. Did you review those documents with your attorney?
Yes, yes.
All right. So I just want to make sure you understand. The state is presenting their evidence now by not calling witnesses. They're just bringing in police reports for the court. Do you understand?
Yes.
Now, if you want to, you can force the state to bring in witnesses to say that you committed this offense beyond a reasonable doubt. Do you understand?
Yes.
So do you want them to present witnesses or no?
Yes.
All right. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Yes.
All right, anything you wish to say on behalf of your client?
No, Judge, we've gone over this and at the time of the incident, it appears that she was under the influence of narcotics. I've conferred with her and believe that she understands everything that she did, and her competency is intact right now.
All right, the court is going to sentence you to 180 days in the state jail facility, give you credit for any time served. The court will request the therapeutic community. There's to be no contact with the Valero located at 12111 O'Connor Road, San Antonio, Texas, 78233. And there's to be restitution to the Bexar County Laboratory for drug testing in the amount of $60. Is there anything else with regards to sentencing?
No, Judge, yes, she's been in custody since 4/16/25. We're asking if she would, if she gets, or if you get the paperwork from the state jail facility to allow the 80/20 credit.
All right, what will end up happening is that's going to depend on any programs that you're participating in. If you're participating in the programs and internalizing everything, I will strongly consider giving that to you. So whether you receive that or not will be completely up to you and your actions. Do you understand? Yes or no?
Yes, ma'am.
Okay. Did you review the trial court certification of defendant's rights to appeal with your attorney?
The one you signed.
Yes.
That's right.
All right, because you entered into a plea bargain agreement, and because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. So here's the thing, Ms. Shaw. It appears to the court that you have a drug problem, right? When you are released from custody, if you cannot find a place, be it a sober living house, or if you have a problem with your sobriety and you just need some extra help with it, if I'm still here, you can come back here and I'll pick up the phone and find a place for you, okay?
Okay.
So only one or two things can end up happening if you continue on this path. Either you're going to end up in and out of somebody's jail or prison, or either somebody's going to have to identify your body. You understand?
Okay.
And I don't want that for you, okay? All right, good luck to you.
Thank you.
You're welcome.
Good luck.
Who is here on Maximiliano Rosales?
Would you, Honor?
So this is motion for early termination?
Yes, Your Honor.
All right, and state, are you opposed to the early termination?
The state is not opposed, Your Honor.
Oh, okay,
Always a bonus.
yes,
I have checked in with your probation office and I'll let her speak for herself.
yes.
Judge, I did check in with the CSO and he says that the probationer has been doing great. He feels like he has been rehabilitated. He has not had any compliance issues and he's in support of the early termination.
All righty, so here's the $1 million question. What have you learned?
Not to be causing mischief and corruption, no, not doing drugs, trying to work, but with my record it's difficult to get a job. I've been doing temp services and but yeah, being productive citizen, that's what I've learned.
All right, so this is what I'm gonna do. I'm gonna follow your agreement and probation. If you can contact Deanna, they usually have specific places that will hire people who have criminal history. And so make sure you contact them. If you contact them, they'll probably be able to have a job for you probably by the beginning of next month.
Okay.
But here's the thing. I always tell people wanted to be president of the company. You got to start somewhere, right?
Yes, ma'am.
So the key for you is, let me just get a job to support myself, and you can still keep looking for other things.
Would it be possible to get it off of my record?
Oh, you'll have to
Talk
speak
about
to your
that.
attorney about
Okay,
that.
all right.
All right. Good luck to you. Congratulations.
Yes.
Thanks for turning your life around.
Thank you.
I appreciate you. Thank you.
All right, you're welcome.
Thank you, Judge.
Right, thank
Ms.
you.
Gonzalez, be excused?
Yes, well, wait till he gets the information so that we can make sure he has employment.
Yes, ma'am. Thank you very much, Your Honor.
You're welcome. Thank you. All right, who's here on Tiffany Martinez? And after Tiffany Martinez, it will be Valdemaro Chapa.
Here, Mr. Chopper, Your Honor.
Oh, that'll be after Ms. Martinez. Hello, good morning. And this is your first setting?
No, we've
No,
been here
it's not,
a few
okay.
times, Judge. We are here on a setting where the state has given a new offer that we'd like 30 days, if the court will give us time to consider this new offer, which is significantly better.
All right, I tell you what, I'll give you 3 weeks because we were actually scheduled for jury trial and today is for us to obtain a new jury trial date. So really recall that's back in 3 weeks. That will be your final plea deadline date.
Understood, Judge.
All right, Ms. Ferguson,
Yes.
I need a 3-week reset for a plea deadline date, and this is the final plea deadline date.
That's fine.
All right, once you sign the reset form, you are excused. What page is she on? Thank you. Valdemaro. All right, so we need a jury trial date.
Yes, ma'am. And Mr. Chapa is here to present himself to this court. He did this court last week. We were vocal with him through that process. He had some car trouble that day. If Your Honor will look at the case file, he has not missed this. We have not had any issues out of
Right,
him.
so here's the thing. He'll need to go in custody, and if you want to call the bondsman.
The bondsman is here and he is willing to remain on the bond, Your
All
Honor.
right, where's the bondsman?
Fernandez, you might just step right
Yeah.
out.
All right. The document I have from the bondsman is a motion to increase bond.
Mr. Fernandez is the bondsman, Your Honor.
All right.
I know him.
Oh, great. I'm familiar with the Birmingham Black Barons from days of old, from history. All right, so with this case, I received a motion for a request for a bond increase. You're no longer requesting that. All right.
And I have a motion for the reinstatement bond if I have to,
All right.
but I'm willing to stay on this bond.
All right. So, state, the court is looking at the docket sheet. He's always been here. Do you have any objection to, the bond remaining the same?
We do, Your Honor. He was set for trial and failed to appear at that trial date. And presented a flight risk to this court and to the state, showing the court that when it's time to go to trial, he's not going to be here. And so for that reason, the state would request that he be remanded without bond. And if the court was inclined to set a bond, then the state would ask for 200,000, which would be, I believe, 115,000 more than his original bond.
All right, so we're gonna go on the record and Mr. Roper, I'll note that you have no objection to the bond being reinstated. So let's see what happens with this hearing.
Yes, ma'am.
All right, thank you.
Thank you.
Court is calling 2024 CR 009634. State versus Valdemaro Joseph Chapa. Can I have parties announced?
Ashley Jones for the state.
Dante Dominguez for Mr. Chapa.
And are you Mr. Chapa?
Yes, ma'am.
All right, so state defense hasn't filed a motion for reinstatement of the bond, but the court will note for the record that the bondsman has presented the court with a document asking that bond be reinstated. And it's the court's understanding, state, you're in objection.
We are, Your Honor. The state just would like the court to note that the case was set for trial, and at that trial date, this defendant failed to appear, showing the court that he has no intention of appearing when it's actually set for trial. And so for that reason, the state would request that the defendant be remanded without bond. And if the court is inclined to set a bond amount, the state would recommend 200,000 and full house arrest GPS.
All right, so yes, if you'll address the issue of him not appearing.
Yes, ma'am. It was last week, I believe it was last Wednesday, or it might have been Tuesday, but he did not appear. It was a car issue. He did attempt to come to court on Thursday. I was vocal with him that day. As Your Honor will remember, I believe you were in trial on that day. And your clerk said that Monday morning would be the best opportunity to be able to flesh this out with the short hearing that we're doing now. So that was my suggestion to him, and he did make himself available that day. I have also consistently been speaking to his bonds person who the court has heard from this morning as well. He is going to stay on it. Now, I have not had a problem contacting Mr. Chapa through the tendency of this case, and this is the first time he's ever raised a court date.
So why didn't he appear? I understand the state's argument that it was scheduled for jury trial. So the question is, if he had car problems, then why didn't he still appear later?
We do not have a good answer for that, Your Honor. He missed court, and we can't make him be here for it.
It was a bad day. My steering wheel got like locked. I broke my key trying to unlock it. My phone died. I didn't have no way to charge it. I started walking, trying to get to a phone so I could call my mom. My mom actually had already left to come here, because if not, she would have gave me a ride and I would have been here. It was just one of those horrible things. You know, I've never missed anything when it comes to court, ma'am. I always show up. I'm always proper. I've never had any problem.
And I can tell the court that his mother was here on that court date, Your Honor.
No, I remember his mother was present, but she's not scheduled for trial.
Yes.
All right, this is what the court is going to do. The court is noting that the defendant has appeared for every setting besides that specific setting. And he has been scheduled for jury trial more than once, and he's appeared when that jury trial was set. Sometimes there's a lot that happens and it hits somebody all at once, and the court is understanding of that. The court will reinstate the bond. The bondsman has agreed to have the bond reinstated. The court is going to give you all a jury trial date if you'll confer with the state, and that will be your jury trial date. This is what I want to stress to you. And we can go off the record. There are not to be any other things piling on top of each other where you don't make it for court. You have to have backup plans. I understand when a steering wheel gets locked. That has happened to me before, and guess what? It's not unlocking. All right, so he can be released. I'm gonna sign the motion to reinstate the bond. Yes, recall the warrant. And bondsman, if you'll give me the documents for the reinstatement of the bond, please. And if you all confer with Ms. Ferguson on a jury trial date for dressing appropriately for court, just have a seat.
Thank you very much, Your Honor.
You're
And
welcome.
once you get that date, maybe you see us.
Oh, you'll have to tell me what the date is.
Yes, ma'am.
Thank you.
Thank you, sir.
Oh, thank you.
All right.
Thank you,
Make sure the
Judge.
clerk receives that.
Okay.
Yes.
September 22nd.
All right, September 22nd.
Thank you, Your Honor.
What's that?
All right, who is, yes. Mr. Woodard? If you come forward, please. All right, Mr. Woodard, your attorney had a medical emergency in his family. So he's asking that you be recalled for the 24th. We're gonna put you for the 24th, but it really depends on if he is prepared to come back. Do you understand?
Okay, that's
All right.
24, 3 days.
Yes.
Okay.
All right, the 24th.
Thank you.
You're welcome. Who's here on Juan Cruz? All right, so in this case, we're here for discovery. Where are we on the discovery issues? Home surveillance from complaining witnesses' phone.
Your Honor, we did speak with the complaining witness's family on Friday, and we are in the process of getting that information. We did get other recordings that we provided to defense this morning, and counseling methods we have received, and they're just in the process of being uploaded. We just need a little bit more time for the home surveillance.
And then was it that the counseling records were sent and under pending transmittal?
Oh, yes, Your Honor. So we've received them. They're just waiting for a paralegal to upload.
Okay, so the only thing that's outstanding is the home surveillance.
Yes, Your Honor.
And I did want to add an ethical disclosure
Oh,
regarding a
yes.
potential witness.
And I'm sorry, what else?
And
An ethical disclosure regarding a potential witness.
All right. All right, how long is it gonna take you all to have that?
Your Honor, it shouldn't take very long at all if the complainant insists mother has it, she'll send it over to us. And the state is prepared to make an offer or has made an offer to defense.
All right, Ms. Ferguson.
Yes.
3 weeks for a final discovery, please. Is that good for you, counsel?
Yes, I believe so.
All right, so August 11th. Is there anything else?
Not from the state judge.
All right, thank you.
Thank you.
Thank you.
May we be excused?
Yes. Lynn Wayne Morren. And there's no application?
There's none, Judge, it says.
Oh.
It's cap offer.
All right. And are you gonna ask for, do you need a PSI and tap, or do you just need a reset for?
Like a PSI, Judge.
All right, what date for a PSI? And is there gonna be any mental health, a make evaluation or no?
I don't anticipate that, but I will have a witness to that effect.
All right. All right. Ms. Abrams, this is gonna be September 15th for a PSI. Court is calling 2025 CR 001248, State versus Lynn Wayne Morren. Can I have parties announced?
Samantha Lynn Brown for the state.
Louis Martinez on behalf of Mr. Morren.
And are you Mr. Morren?
Yes, yes.
Counsel, have you received all discovery? Did you review that with your client?
Yes, Your Honor. The discovery that I could review with him, I reviewed with him.
Court will find that the state is in compliance with discovery. Mr. Morren, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Morren, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, you're charged with possession of child pornography with a child younger than 10 years of age. As a first-degree felony, the range of punishment is anywhere from 15 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, Your Honor.
By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Morren, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
That's your copy.
Thank you, Your Honor. You're welcome.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to your plea, your punishment is to be assessed at a cap of 30 years in the prison. There's a $5,000 fine. There are no applications in Chapter 62 compliance. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and voted upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
State offers States Exhibit 1 and all attachments and States Exhibit 2 and its contents. And at the same time, I would move for that motion to seal to be signed for the contents of States Exhibit 2, which contains the child pornography images in this case.
That's all without objection, Judge.
All right. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Did you understand that there are certain documents that contain child pornography that your attorney and the state have agreed that that would be sealed?
Yes, Your Honor.
And did you understand that in order for it to be unsealed, someone, an attorney or a party would have to file a motion and have a hearing, and the court will make a ruling on whether or not to unseal that?
Yes, Your Honor.
So after today, do you understand that that document or those documents will be sealed, and those documents will not be accessible to the court or to the state or to the defense or to you? Do you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. This will be set for sentencing on September 15th. Once you sign the reset form, you will be excused, and if you'll talk with probation, they will do what's called a PSI investigation. It's not for purposes of probation. It is merely for me to obtain more information about you. Do you understand?
Your Honor.
All right, thank you.
And Judge, just
Yes.
really quick, did you admit State's Exhibit 2 as well, which is the sealed?
Yes.
Okay, perfect. Just want to make.
Thank you.
Thank you, Judge.
You just.
All right, thank you. Maverick Dennis Inennis. Court is calling 2025 CR 002989, State versus Maverick Dennis Inennis. Can I have parties announced?
Deputy Pitlock for the state of Texas, Your Honor.
John Robertson for Mr. Ennis.
And probation, this is an application. All right. Are you Mr. Innes?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Innes, did you review the application for community supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Ennis, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with the offense of criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call them the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am, I fully understand.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Ennis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am, under no circumstance.
Anyone promised you anything other than the plea?
No, ma'am,
Are you satisfied with the way you've been represented?
fully.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. The state recommends community supervision. They're taking in consideration 2025 PF 12413, 2025 PF 12414. There's to be restitution to Cornelius Meister, Meister, Marlene, Marlene, Pollard, Pollard, and 2025 PF 12414. There's to be MRT, no contact with the complainants, tap evaluation and follow all recommendations. Did you understand that to be the
Yes,
plea?
ma'am, I fully do.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
No, I fully did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No,
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a top evaluation, 100 hours of community service restitution, and no contact with the complaining witnesses. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
Yeah, no more fouls, please. All right, I'll pick it up after lunch. All right, state, any evidence to support the defendant's plea?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
no objection.
All right, did you review the waiving stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I fully understood.
Again, did you understand you have a right to jury trial and the right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right. So it says damage to a vehicle, $3,609.22. Are you all agreed to that amount or no?
It appears that's an accurate amount. There's an estimate in the STIPS, Judge. And
Okay.
it was some body damage in a window. And the way the body repair business is now, it's no small damages that I'm aware of.
All right. So that amount goes to Cornelius Meister, $3,609.22 restitution to Cornelius Meister. I don't see the restitution amount for Marlene Pollard. Do you have a restitution amount?
Your Honor, those are for the TIC cases.
I think it's gonna be less than $100, Judge.
All right. So, Mr. Innes, it appears that you have a problem. What is your problem?
I made a mistake. I was going through like a life change. My mother and my child had left me, so I just started making irrational and
I mean, sometimes people leave people for good reasons. I don't understand how that equates to your
I was
being abusive to a dog.
yeah, it wasn't that half the statements is not true. Just I had somebody that had in my life that wasn't the best for me, and then they was doing anything to hinder me. But I'm not trying to minimize or justify my negative behaviors. I just made a crucial mistake in my life, and I'm
No
willing to-
crucial choices.
Yes, ma'am.
So here's my question. They say that how this all started is that it states, victim states he was waiting in the parking lot of the listed location for his friends, just minding his business, waiting for his friends. Victim states he saw a suspect, that's you, chasing after a dog and beating it.
And those some of the things are not accurate, but
Well, is that accurate?
I never touched the dog. I was maybe yelling at my dog trying to get it back in the house, but I'm not like once again, I don't want to minimize justify my negative behavior. So
Well, I'm gonna tell you right now, I'm not gonna allow you to have any animals. I don't know why people want to get dogs, get pets. They don't get them their shots. They just keep them chained outside and like, here's some water and some food. Now, there are different standards for dog treatment. Number one, they have to have their vet bills and they need to get seen by a veterinarian on a regular. And if you can't do that, that means that you can't afford an animal and you shouldn't have one.
yes, ma'am. I haven't had.
I'm sorry?
I'm so sorry to interrupt you. I haven't had one since.
Well, I will not allow you to have any pets, not even a goldfish.
Yes, ma'am.
Do you understand? Or those hermit crabs that they're so fond of giving away at the fairs. You are not to have a living, breathing, any type of pet.
Yes, ma'am.
The bearded dragons, a bird, whatever it may be. If it has a pulse, If it's living, breathing, all creatures great and small, not allowed.
Yes, ma'am.
I'm not gonna allow you to have any contact with minors. And let me just tell you why, because this is concerning to me that you were beating a dog. Now, I will order parenting classes because you're saying you have a child.
Yes, ma'am.
And once he completes parenting classes, then I'll consider lifting that.
Yes, ma'am.
When's the last time you had employment?
I was currently employed prior to me being here.
Doing what?
Lawn care.
All right. And how many children do you have?
I have 4 kids that have full custody of.
So who are they with now if you have full
My
custody?
significant other.
And is she the biological mother of
Yes,
these
ma'am.
children?
Yes, ma'am.
All right. So I don't know where you're gonna be living, but I'm not gonna allow you to reside in a home with minors either. Because I find this dog issue very concerning.
Yes,
Have you ever had any type of mental health issues?
Yes.
All right. So what has been your previous diagnosis?
I suffer from severe depression and anxiety. And I have anxiety, I have sleeping disorder.
All right.
And
And
currently,
then have you ever used drugs in the past?
Yes, ma'am, but no, currently.
And what would those drugs be?
Marijuana.
All right. So as previously stated, the court is finding him guilty. The court is going to sentence him to 2 years in the state jail facility, suspended and probated for 4 years. Taking consideration 2025 PF 12413, 2025 PF 12414. There is to be restitution of $3,609.22 to Cornelius Meister. There's to be restitution, if any, to Marlene Pollard. And cause number 2025 PF 12414. There is to be a TAP evaluation and MIC evaluation in custody. Follow recommendations. There's to be no contact with minors. There's to be no residing with minors. There's to be no contact with animals.
Yes, ma'am.
And for the court, an animal is all creatures great and small. You can't do a mouse, you can't do Michael Jackson, Ben, none of that. You understand?
Yes, ma'am.
So no contact or ownership of any animals. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days, no employment as a home health care provider or with minors, 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Probation, I'm sorry, I'm going to need field visits 2 times per month until further notice. And if you could have somebody please go to that house, check on the children that are in that house and make sure everything is safe with them. Is there anything else, probation?
No, sorry.
Is there anything else you need from the?
Are they Pollard?
Pollard, Pollard. Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you're gonna have to do better and we're off the record, find your empathy, sympathy bone and put it at the forefront of your life. You understand?
Yes, ma'am.
All right, good luck to you.
He also had a family violence assault, Your Honor.
Okay. All right, just 1 second. I'm sorry, Mr. Pollard, come back. So who is the complainant in the assault family case?
Her name is. Might be mispronouncing it, Montisha Nicholson,
Can you spell the first name?
MONTEYSA, and then Nicholson of Mississippi.
All right, we're back on the record and cause number 2025 CR 0022989. And there's also to be no contact with Montesa, MONTEYSA Nicholson. And the court will take in consideration 2025 PF 22670.
Yes, ma'am.
Thank you. DeMonte LaRoberts Williams.
If you're reaching back with Michael Jackson, Ben,
Huh?
we're reaching back.
Hey, Ben, the two of us need look no more. We both found what we've been looking for. Hello, come forward. All right, state, on this case, do you have all the discovery?
So, Judge, we do. The issue is we've got an unindicted case that's of a substantially higher degree of offense that has not been indicted.
And what case is this? What's
An ag assault, Judge.
All right, state, I'm gonna recall this in 30 days. Y'all need to let me know what's happening with the other case, if it's gonna be presented or not.
Yes, Judge.
All right, Ms. Ferguson, on Robert Williams, if I can have a 30-day reset for discovery. And you need to make sure you're on time for court. Court is at 9 a.m. You understand?
Yes, ma'am.
All right. All right, we'll bring you back on August 19th. Once you sign the reset form, you are excused.
Thank you, Judge.
Thank you.
Roman Flores. All right, so today is discovery day.
Yes, Your Honor, I have all discovery in the case. There is an offer that's been made by the state. We're requesting that the court set a plea deadline.
All right, sir, how old are you? All right, Ms. Ferguson, if I can have a 2-week reset for plea deadline date, please. And it's Roman Allen Flores. All right, August 4th.
Thank you, Your Honor.
Okay, bring Mount Council up.
I just need to let the court know that I filed a motion for insanity.
All right, so I'll have to take that up at, after recess.
Which has to be brought up again, didn't it?
No, Mount Council.
Yes, that's the one.
Oh, then it's not why is it set for a plea if it's for Saturday?
I don't know why.
All right.
So it's been filed.
All right, Mount Council, what date? Have you already filed the
I have
Saturday?
filed it.
I've been in jail, June, I haven't been in court yet.
Oh, Miss, you were in court on June 24th.
They broke my house, I'm in bad shape, I can't even get out of bed.
All
I can't
right.
even go to the bathroom, and they won't give me some supplies, they're finally getting some supplies for me.
All right, well, Miss, all
Prescribed in my home.
right, Miss Mount Council, you were you were scheduled for court on June 24th, but your attorney was in jury trial in Comal County. And then we brought you back for July 7th. And I believe we had that by Zoom. And so now you're here today. Ms. Ferguson, set it for 45 days. They should have the sanity evaluation completed by then. All right, September 8th.
Help. And I'm really embarrassed, I'm in such bad shape, and I stink as I do.
All right, no problem.
And I can't, I'm not that way, I'm kind of person.
All right, thank you. John Martinez. All right. Oh, is Cindy there? Hi, okay. All right, the court is calling 2025 CR 0000072 State versus John Anthony Martinez. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Leo Gonzalez for John Martinez.
And are you John Anthony Martinez? Counsel, have you received all discovery? Did you review it with your client?
Have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
And probation, this is an application. Mr. Martinez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
You're charged with the offense of aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes.
Did you understand that?
Yes.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication. There's to be restitution of $60 to DPS and also restitution to Elias Aguilar Bautista. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you understand if the court finds that there is a deadly weapon involved, the court will enter a affirmative finding of deadly weapon?
Yes.
Knowing that, do you still wish to proceed with this plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Elias Aguilar Bautista, and is this Ojos Locos, the DWI education course, victim impact panel, ignition interlock for half the term, and the driver safety course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objection, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? And state, you may be excused.
Thank you, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yeah.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. I just let the court know he has completed the victim impact panel already, as well as the DWI education class. He is a new father as of about a month ago. Yeah, about a month. He does work. He works for the local union here. He is looking to get back into doing solar. He did it previously with commercial businesses, looking to do it with residential. He has understood the consequences of what he put himself in during this incident. Has worked hard to maintain his sobriety and to maintain a lifestyle for his family and his newborn child.
All right, so what do you do for a living?
And I work for the local union for Austin.
I'm sorry, what?
Local union for electrical workers
Oh, okay.
for Austin. I'm thinking about going back to doing solar though. For computer, but it's all locally. Austin, Kyle, some markets in Brownforth.
Okay. And is this your first child?
Yes. I have a adopted daughter as well.
Okay.
She's my wife's cousin by blood, but we're adopted.
So what have you learned from this?
Quite a bit. It's nothing to play with. And all that, sure.
All right, there's gonna be a $2,000 fine that will be probated, regular and random UAs, restitution, if any, to Elias Aguilar Batista, $60 to DPS, regular reporting by Zoom or in person, 8 years deferred adjudication. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's complete, the community service hours will be deemed satisfied. Proof of employment within 30 days. No employment as a home health care provider or with minors. Ignition interlock for half the term. DWI education course. VIP live. Driver safety course. Field visits 1 time per month for 3 months. There's an affirmative finding of deadly weapon. And so I'll notice that there has been this is not a DWI case. It's because it appears from what I read in the police report, you were also texting. And if you take your eyes off the road for even a second, things can go haywire, you understand? They used to have a commercial, and I don't know if it was all over Texas, but it was in Louisiana. It would show a person driving, and it would say they didn't like the song on the radio, so they killed a child. And what it was somebody would take their eyes off the road, and they would change the radio, and they would hit a child just crossing in the crosswalk. So you have to pay attention to everything, you understand?
Yes, Your Honor.
There's to be no contact with, they tell me this pronounced hosts, JOS, locos, ojos, locos. Probation, is there anything else? Yes. Thank you.
And Judge, in regards to that, he was in a work vehicle at the time, so he's gonna look into whether or not insurance took care of that particular issue.
Well, I will tell you what I remember from law school. If it's outside the course and scope of your employment, usually everybody will go to civil court and they'll settle it there. All right, Ms. Ferguson, I need 60-day reset, and that's just for restitution. Is there anything else you need from the court to be successful?
One other thing, Your Honor, has had an ignition airlock on his vehicle. He's had some mechanical problems with the ignition airlock. He's tried to go in and have it fixed. Haven't been able to take care of that. So I don't know if the court will consider doing a portable device instead, because it is more consistent at this point than the ignition airlock.
If he provides proof that he does not have access to any vehicle, does his wife drive?
Yes, yes.
All right, there needs to be ignition interlock then on your wife's vehicle.
Okay.
All right, what date? All right, September 18th will be the date for the restitution hearing. And you are not allowed to drive. Ms. Abrams, no driving of any vehicle not equipped with ignition interlock. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record in this court. If there's something you do not understand, or you have a question about anything, speak to your probation officer. If you need help with anything, let your probation officer know. If you feel like they're not addressing it, you can always come back to the court.
Yes, sir.
All right, just have a seat, and they're going to go over conditions with you.
Who do you?
8 years.
Matthew.
No, that's all I have, maybe excuse.
Yes. Arturo Lopez. All right, the court is calling 2024. The court is calling 2024 CR 010499. State versus Arturo Lopez. Can I have parties announced?
Ducky Pitlock for the state of Texas, Your Honor.
The attorney of record is Monica Guerrero. Joseph Davidson covering for today. Mr. Lopez, will you give me permission to do this in place of Ms. Guerrero?
Yes. All right, and we have an interpreter present. If you can raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Mariana Rios.
All right, Mr. Lopez, all of these documents are in English. Were those documents explained to you in Spanish?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Mr. Lopez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it?
Yes.
You're charged with collision involving serious bodily injury. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
All right, defense, have you addressed with your client the impact this plea will have on his immigration status?
I have, Your Honor, with the assistance of an interpreter, I've complied with the, I've explained the immigration consequences to him. He understood them. And negotiating the plea offer, we discussed his options and, knowing that these consequences exist, he does not want to face a jury trial. We negotiated a plea that he's accepting, as long as the judge follows it.
Mr. Lopez, do you understand by entering into a plea bargain agreement in this case, you will be deported? Do you understand?
Yes.
Do you understand you will be denied naturalization?
Yes.
Do you understand you will not be allowed re-entry into the United States?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. There are no applications. There's to be restitution to Emily Garcia and Yvette, Evett Quintero. Did you understand that to be your plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objection, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and stipulated to the testimony and stipulations in State's Exhibits 1 and attachments, and the court will accept the same into evidence. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we wish to waive PSI and we ask that you follow the agreements.
All right, the court will sentence you to 5 years in the prison. Give you credit for any time served. There's to be restitution to Emily Garcia and Yvette Quintero, and there's to be no re-entry into the United States. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you, sir.
Your
Thank
Honor,
you.
If I may,
Yes.
this doesn't resolve all his cases. He understands that there is a misdemeanor out of Bear County that he'll have to resolve separately. The state would not agree to TIC it. He'll have to plead on a evading arrest that's listed on the docket. And additionally, there's a out-of-county case. I could not locate a case number. We just asked that if, in the event that he needs back time credit, if you could run this concurrent with any active case he has.
All right, just one moment.
I believe he was on the first page.
Ah, you're right. All right, we're back on the record. This will run concurrently with 2024 CC 738399. Any other out-of-county matters, counsel, you'll need to bring that to the court.
Yes, Judge. If I get the cause number, I will come back.
All right, thank you.
Thank you, Judge.
Are the parties here in Clinton, Dixon?
Yes, Your Honor.
Good afternoon.
Good afternoon. How are you doing today?
Hi.
Oh, I understand. All right. So this is the final plea deadline date.
It is, Judge. I'm still waiting on Dr. Murphy. On the report from her. I called her office this morning. She's going to interview Mr. Dixon tomorrow.
Mhm.
I really, I tried to pin her down on a deadline 2 settings ago
Mhm.
in this court. I'm a bit frustrated by it. But I still need a report before I can negotiate on a plea agreement.
Mhm.
A minimum of at least 2 weeks.
What I'm gonna do is I'm gonna set it for jury trial.
Okay.
And you can speak to the state and about whatever y'all want to speak to.
Okay.
All right, Ms. Ferguson. I need a jury trial date. And this trial will probably be 4 days. And just put it for a jury trial on all cases. And is Clinton Dixon. Sir, if your attorney wants you back sooner, then they will let us know and we'll have you brought back sooner, okay? All right, what will happen is we'll put you down for October 14th. That's the earliest we can get you in. If for some reason we're able to get you in sooner, we will have you brought over sooner. Or if your attorney wants you brought over sooner, he'll let us know. Do you have any questions about anything, sir?
No, ma'am.
All right, thank you so much for your patience.
Judge, I appreciate it. Have a good
Thank
day.
you. You too. Are the parties ready on Noah Javier Gonzalez? All right, the court is calling 2024 CR 007423, 2024 CR 007444, 2024 CR 6757, State versus Noah Javier Gonzalez. Can I have parties announce?
Deputy Pitlock for the state of Texas, Your Honor.
Humberto Saldaña for Noah Javier Gonzalez.
And are you Noah Javier Gonzalez? And each of these cause numbers, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
And cause number 2024 CR 007423. Are you the same Noah Javier Gonzalez who's placed on deferred adjudication for theft of property, $2,500 but less than $30,000 on September 23rd, 2024 for a period of 4 years?
Yes, ma'am.
Are you the same Noah Javier Gonzalez who's placed on deferred adjudication in 2024 CR 007444 for the offense of unauthorized use of a vehicle on September 23rd, 2024 for a period of 4 years?
Yes, ma'am.
And are you the same Noah Javier Gonzalez who's placed on deferred adjudication in 2024 CR 6757 for the offense of theft of property, $2,500 but less than $30,000 on July 16, 2024 for a period of 2 years? Is that you?
Yes, ma'am.
All right, State, are you proceeding on the same allegation in each motion?
Yes, Your Honor.
All right, State, you may proceed.
Violation of condition number 4, in Bexar County, Texas, the defendant, Noah Javier Gonzalez, did then and there fail to report to the supervision officer as directed for the month of December 2024 in violation of condition number 4.
And each cause number, how do you plead to that, true or not true?
True.
The state will waive and abandon the remaining violations in each cause number, Your Honor.
Any objection?
No objection.
In each cause number, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and each cause number, the court could sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4 in each cause number?
Yes, ma'am.
In each cause number, the court will find violation of condition number 4 true. Is there a proposed agreement?
There is, the state may believe that defense may want to speak to a condition, but there is an agreed recommendation, Your Honor.
And what is the recommendation?
That is to deny the state's motion to continue probationer on deferred in all 3 cases, but to amend conditions to now include safe PF in each 3 causes.
And Your Honor, we wanted to address that if we could, put on some, I wanted to call my client.
All right, so here's the question. Was he in a coma? Because we haven't seen him since December. So is there a reason why nobody's seen him since December? Because that's December, January, February, March, April, May, June, and now we see you. That's 7 months later. So is there going to be information that he was in the hospital or being held hostage in some kind of way he couldn't make it?
Judge, but I do think that there's some mitigation that.
All right, let me hear the mitigation. I'll keep an open mind, but let me hear mitigation. Who are you calling?
Mr. Garcia first, and then his mother is here also.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
No, Javier Gonzalez.
All right, you may proceed.
You've been incarcerated in Bear County, how long, sir?
As long as I was in Bear County for like 3 months.
And how long? My question to you is, when were you incarcerated on this MTU?
This NCR on June 14th.
June 14th, okay. Prior to June 14th, what was your status as far as residing with your mother?
I ended up having to go live with my father in Marble Falls, which was all communicated through my probation officer. She knew that I went out there.
So the probation officer gave her blessing for you to.
I gave her proof of address and everything, and proof of job. I was working in Marble Falls.
Do me a favor, wait till I finish my question before you answer, because she's taking down everything you say,
Yes, sir.
and that way we can have a clean record. So when did you go move with your dad to Marble Falls?
2 months after my release.
And when was your release?
I was released in November. I want to say November, between November 15th and November 23rd.
Of 2024.
Yes, sir.
So how many times had you reported to the people in Marble Falls?
I didn't report to nobody in Marble Falls. I was coming back every week to report down here in the Windcrest office.
Okay. When you say every week, when can you give the court the dates of when you came to report to Windcrest?
It was once a week. I don't know the exact dates, but it was once a week. I came back every Thursday, every Friday. We would come back, me and my dad, and I would report Friday.
Okay. And
So I'm sorry. So is he saying that he actually reported December? Is that the testimony I'm hearing?
that's,
I did report. I took a urinalysis, and
No. Here's my thing. I don't understand the plea of true if he's telling the court that he reported December 2024. If he's saying he was reporting, then sounds like we need to have the probation officer zoom in, if nobody has any objection, to tell the court that he was actually reporting, because he's just pled true to not reporting for December 2024. And what I can tell you, usually when it says you haven't reported since December 2024, that means that probation has not seen you since December 2024.
yes, ma'am. But I definitely did report. I was going once a week.
Then
Judge, I don't mean to.
No.
But I think that the allegation says he didn't report in December 2024, not,
Yeah.
he didn't report then, and January, February, March, April, May. I don't believe it says that, but I could be wrong.
No, it says in Bexar County, Texas, the defendant Noah Javier Gonzalez did then and there fail to report to the supervision officer as directed for the month of December 2024 in violation of condition number 4. So my understanding about rules of, conditions of probation, we can go off the record. They will give you a specific date to report in December. You don't get to choose which date you report from. They'll tell you, we want you here on December 14th, whatever they'll tell you. Once you report, they mark it off that you report. And then they'll tell you the next month what day they want you to report. And usually it's the same day unless something happens and it falls on the weekend. So what I'm hearing from your client is he's telling the court he reported December. Is that what I'm hearing? Do we need to have the probation officer zoom in? Because if he reported, then I don't know why we have this motion to revoke, but they're saying they haven't seen him since December 2024. And if he's telling me he's reported, then maybe he shouldn't be here.
Judge, I hate to go back to this, but I think as to December, you didn't report. Is that what you're saying? But all the other months that you reported, is that what you're telling?
I don't remember reporting in December, but I know for a fact that I reported multiple times throughout those 7 months that I was on
All right,
probation.
Ms. Abrams, this needs to be cleared up. Is it possible? Does anyone object to the probation officer zooming in?
No,
The state does not.
defense does not.
All righty. And Ms. Abrams, he's saying he reported here in Bear County. So if you all have a seat, the probation officer will zoom in and we'll see what's going on. Who's here on Shannon Patton?
On that, Judge.
And is this an application or no?
No.
All right, Ms. Patton, if you'll come down. All right, the court is calling 2025 CR 0071189, State versus Shannon Marie Patton. Can I have parties announced?
Ducky Pitlock for the state of Texas, Your Honor.
Ring bell for the defense, Your Honor.
And are you Ms. Patton?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Ms. Patton, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state will be proceeding with the lesser included possession of a controlled substance, penalty group 1, less than 1 gram, to make this a state jail felony.
Any objection?
No objection, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, the state is proceeding on possession of a controlled substance, penalty group 1, less than 1 gram, as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Patton, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense. They're asking that your punishment be assessed at 300 days in the Bear County Jail under 1244. There are no applications, and there's to be $60 paid to the Bear County Crime Lab for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, ma'am.
Then to the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. How do you plead?
No contest.
State any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
We reviewed the same. No objection.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney To cross-examine and confront any witnesses the state would call and the right to remain silent.
I understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
We just asked the court to follow the plea agreement of the parties, Judge. My client's been in jail for about 160 days. And she understands her situation. We reviewed all the circumstances around the case, and she believes this arrangements in the best interest for her.
All right, the court will sentence you to 300 days in the Bexar County Jail under 1244. Court will give you credit for any time served. There's $60 restitution to the Bexar County Laboratory for drug testing. There's to be no contact with Texadelphia, Texadelphia. Is there anything else with regards to sentencing?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You are at a crossroads in your life. How old are you?
Just turned 41.
All right, so you're gonna have to make a decision. Either you're gonna end up spending the rest of your life in somebody's prison or somebody's jail, or either somebody's gonna have to identify your body. That's what usually happens when you're constantly using drugs. When you're released from custody, if you can't find a place, a sober living house, or get help for any addictions you may have, if I'm still here on the bench, you can come back here. I will pick up the phone and find a place for you. Do you understand?
Yes, ma'am.
And here's the other thing. I don't know. Sometimes people will do this and they think they're getting 2 for 1, 3 for 1 at the jail. I am not in charge of whether you get 2 for 1 or 3 for 1 at the jail. So if you feel as though the jail should give you 2 for 1 and they're not giving it to you, it will do you no good to contact the court, because that is not a part of my jurisdiction. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, sir.
All right, Devin Berry.
Good afternoon, Your Honor.
Good afternoon. Where's Mr. Berry?
Just right here, Your Honor.
All right, state on this case, were you able to tender an offer?
Your Honor, the state has made an offer. We do intend to pursue.
Okay.
And Mr. Berry wants to be on that offer. However, I just need about maybe a week to let his family know what I'm doing. Why that's important to me, I know his entire extended family, all the way back from high school.
Okay.
And I want to know what I'm doing, where it's going to take us.
Do you want to recall it for next week?
That would be great, Your Honor.
All right, what day next week?
Whatever's good for the court.
All right, do you want Monday, Tuesday, or Thursday?
How about Thursday? That would be great, Judge.
All right, Ms. Ferguson, if we can recall this Thursday of next week. All right, so we'll bring you back on the 31st. Once you sign the reset form, you're excused.
There will be a plea on that day, Your Honor.
All right, thank you. Good seeing you. How's your wife doing?
It's a very rough month and a half. She's a Methodist for like nearly a month. Then they sent her to the wrong hospital for follow-up. And now she's back in Warm Springs and being released Friday to come home.
All right. All right. Thank you. Have a good one. Tell her I said hello.
I will. Judge, it was a pleasure to see you.
You too, always. All right, Umberto,
Yes, Judge.
we are ready.
Okay.
Oh, Mr. Sawyer, so your client will need to sign the reset form. All right, thank you. All right, we are back on the record in 2024, CR 007423, 2024 CR 007444, and 2024 CR 6757, State versus Noah Javier Gonzalez. Could I have all parties re-announced, please?
Duffy Pitlock for the state of Texas, Your Honor.
Humberto Saldana for Noah Javier Gonzalez.
All right, So where we are is your client has testified that he actually reported in December 2024. So is there any objection? Because we can just get to the point with the probation officer, either he reported or he did not. Any objection to going out of order and just calling the probation officer?
No objection from the state, Your Honor.
Yes.
What I had stated was, I'm not sure if I reported in December, but I'm sure that I reported multiple times.
Oh, we're gonna find out what's going on from probation. Any objections?
No objection.
All right, and the probation officer is by Zoom. Any objections to the officer being by Zoom?
None from the state.
None from defense.
All right. Officer Neal, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name and occupation for the record.
Kiana Neal, supervision officer.
All right, does anyone want to question her about the allegations in the motion?
The state may begin. Officer Neal, the state read a violation. It was number 4, that in Bear County, defendant failed to report to the supervision officer as directed for the month of December 2024 in violation of condition number 4. Defendant did plead true, but then there was discussion as to whether defendant did or did not report in December. So the state's one question would be, according to your records, did defendant report for the month of December as directed according to the conditions of his probation?
No, he did not. I did have collateral contact with his mother, but not him.
Now, does collateral contact count as reporting under the terms of the contract?
No.
And would that have been described to defendant? Like, did he know collateral would not work?
I think at that point he had just got out of custody. He was in Bear County for a new offense prior to that.
And
so
when
I hadn't met him just yet.
You had not met?
No, sir.
Now, when probationer is released, does someone go over the terms when he's released, or that would be you and that did not happen?
Correct. We were waiting for that appointment, which he didn't show up to.
Now, is not showing up to the appointment a violation?
Correct. It's failing to report for that month.
Then, Your Honor, the state does not believe we have any further questions.
Any questions?
Were you aware that Mr. Gonzalez had tried to transfer his probation to another county?
Yes. We did talk about that, and he said he was no longer looking to transfer his probation.
And are you at the Windcrest office, is that right?
Correct.
Okay. And how many times did you see Mr. Gonzalez during the time that he was on probation?
4 or 5 times.
4 or 5 times. So that would have been, is it once a month reporting?
Well, he's on weekly.
Weekly? Okay. So do you know what months that he reported to you if he was weekly?
Okay, give me a second. All right, can you give me a second so I can get that information for you?
Sure.
All right. All right, he did come in February. Of 2025.
What about March?
Yes, he came in March.
How about April?
Hold on, I'm scrolling through to make sure. I do not see where he reported in April.
Okay. Did he show up in May?
No.
And he's been in custody, if you know, since June the 14th, is that right, of this year?
Correct.
So,
April and May he did not, and then he was arrested in June. Is that your understanding?
Yes,
So he's been in custody roughly about a month and a half.
correct. And he did have a couple issues with charging his device, his GPS device as well.
Okay. So was that mainly due to monies?
So charging it has nothing to do with money.
Okay. So what was the, did he have a solid residence at the time that he was on reporting?
So we did talk about how he did have some family issues.
And were those family issues regarding his mother?
Correct.
And in essence, his mother was not allowing him to stay at her house, is that right?
Yes.
Okay. So when he would go to Marble Falls, is it your understanding that he would spend the night in Marble Falls?
We did talk about it a couple times. I tried to get him to give me proof of residency there.
Okay. But you did understand that he was contending he was living in Marble Falls and then commuting back to report to you.
I'm sorry, you breaking up.
You did understand that he was living in Marble Falls. That's what he was saying, and he was traveling back to report to you.
So yes, I was gonna get him to provide me proof of residency so we could get it to judge.
Okay. And the allegations or the allegation of not reporting, it's not like you're saying that you haven't seen him since December, right?
No, so I did see him periodically through the time that he's been on.
And do you know how old Mr. Gonzalez is?
He's 19.
19, okay. And so you would say that's a pretty young man? Would you agree with me on that he's a young man?
Yes, he's grown.
Okay. And Mr. Gonzalez took some UAs for you as well, did he not?
He did.
And they were all negative?
Correct.
Okay. Did he ever give you any concern that he was using drugs or alcohol?
I received some anonymous phone calls that he may have.
But that never was borne out in the tests, right?
No.
I'll pass the witness.
Any further questions?
Nothing.
All right. So here's, and this is not a question for you, but it's a question for attorneys. I didn't give anyone permission to reside in Marble Falls. That's one of my questions. And my other question, if his mom wouldn't allow him to live with her, then why is she in court today? What is the purpose?
Judge, I think she wanted to explain that. I think she's here to support him. She may not agree with everything Mr. Gonzalez is doing, but she's here to explain that she loves her son and she hopes that one day he'll get it right and.
All right.
All
All right, that'll be noted. Your mother loves you. She hopes one day that you can get your life together. Do you understand? And you haven't been doing things that you need to do in order to get your life together. Because I had you on a curfew. I had you on GPS. There were no issue with fees because the fees were waived and he's supposed to be on curfew, but he's just doing what he wants to do. Oh, let me go to Marble Falls. And I know I specifically told you if there's an issue, all you had to do was contact probation. You're here for 3 felonies, and now it appears that someone wants to do this. He's only 19. He tried to report, didn't do it well. He's on probation for 3 felonies. And, somebody wants to do the Puss in Boots eyes at me as though, I'm 19, woe is me. I don't understand.
No, Judge, I don't think that that's what really is trying to be conveyed. I think what it is that Mr. Gonzalez had not been in this position before. And I think that out of necessity, because he couldn't live with his mom, he had to go live with his dad and he doesn't reside in Bear
And
County.
he didn't pick up the phone and he didn't call probation or come back to this court on all the trips that he would come back to this court and say, Judge, I have an issue. I can't live with my mom.
If I may,
Yes.
I did tell her about my situation when I went and for going to Marble Falls, and I did ask a request for some type of compliance there with you to go over it, but I never got a compliance on.
Nobody came to me with a compliance hearing. So, State, what are you asking for?
We originally asked for the 3 motions to be denied and to continue probationer on deferred, but to amend to include safe P for a more structured environment.
All right, so here's what's gonna end up happening. One or two things. He's not getting out of custody today. How he wants to spend that depends on him. One, I can revoke you. And I understand you have issues. You're 19. You say your mom doesn't want you living with her anymore. So I can send him to the state jail facility, and I'll send him to the state jail facility for 200 days. Or he can await transfer to inpatient drug treatment. Those are his only 2 choices.
I'll take the first choice.
What, you want to just do your time? All right, so let me explain. I'm going to give you a chance to talk to your attorney about that, because let me just tell you what that's going to be. That's going to be a felony conviction. Have you ever had a felony conviction before? We can go off the record. There are consequences to felony convictions. And let me just tell you, what you're charged with, the theft cases, those are what are called crimes of moral turpitude. If you were to be charged with murder and get convicted of a murder, that's not necessarily a crime of moral turpitude, but theft is. And that is a bigger stain on your record than having gone to prison for aggravated assault with a deadly weapon against somebody who wasn't a female, because charges against females are crimes of moral turpitude, right?
Yes.
And with crimes of moral turpitude, that means that anything that has to do with license that you're trying to do for yourself, it's going to be extremely difficult, if not impossible, for you to get that license. It's going to be slim to none. And then there are issues with your voting rights being taken away. And there's your issue with being allowed to serve on a jury, because those are crimes of moral turpitude, and because they are felonies. So you may want to discuss that with your attorney. And I can tell you also, with a felony conviction and crimes of moral turpitude, if you're thinking of getting some type of school aid to go to college, or you have a child and something happens and your child needs help, or you need help through WIC or SNAP or whatever it is, you're not getting it because of this. Do you understand? So I'll let you discuss it with your attorney. Court is calling 2024 CR 008934, State versus Matthew Longoria. Can I have parties announced for the record for the state?
Deputy Collector of the State of Texas, Your Honor.
Defense?
Thomas Hill is standing in for Attorney Travis Kepmeyer with client's consent.
And are you Matthew Longoria?
Yes, Your Honor.
And do you consent to this attorney standing in?
Yes, Your Honor.
All right, Miss Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with Mr. Longoria?
Attorney Kepmeyer has, Your Honor.
Have you reviewed all the discovery with your attorney?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Longoria, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Longoria, did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
You're charged with theft of property, $1,500, less than $1,500, with 2 or more previous convictions, which makes it a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility, and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call them the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication, is there an application for deferred?
No, Your Honor.
All right. It's just that the paperwork says that. Let me see. Not your paperwork.
Dr. Kepmeyer informed me it was just before probation, Your Honor.
Okay. Any objections to the court just circling community supervision?
No objection.
None from the state.
Okay. Counsel, has your client been able to provide you with any defenses?
No, Your Honor.
Do you
Yes, ma'am.
believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Longoria, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. The state is recommending community supervision. There's to be restitution to Walmart, no contact with any Walmart, the theft course, TAP evaluation, MRT, and 100 hours of community service restitution. Did you understand the theft course, the TAP evaluation, the MRT, and 100 hours of community service restitution, that part of your agreement, the court does not have to follow?
Yes, Your Honor.
All right, other than that, did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, ma'am.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There'll be 100 hours of community service restitution and no contact with the complaining witness. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers States Exhibit 1 and all attachments at this time, Your Honor.
No objections, Your Honor.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes,
Anything you wish to say on behalf of your client?
just for the court to please respectfully go along with the plea bargain made.
All right, how long have you been using?
Drugs.
Yes.
In about 2 years.
And what have you been using?
Just heroin.
All right,
I've never shot up with the needle or anything like that.
all
It was
right.
just a dumb choice that I made.
All right, so here's the thing. I can tell you what's going to end up happening is that I'm going to place you on probation, but you're not going to be released from custody. The TAP evaluation is going to be done in custody. There's going to be a referral to felony drug court. And you need to be honest with them for that evaluation. And more likely than not, you're going into inpatient treatment. So if you don't want the inpatient treatment, now's the time to say so.
I don't want the inpatient treatment.
All right, so do you want to discuss? Do you just want to do 2 years in the state jail facility then?
No.
I mean, you're going to end up doing times, or either you're going to follow the court's recommendations.
It's on probation?
Mhm.
I'll follow the probation.
All right. So the court is going to sentence you to 2 years in the state jail facility, suspended and probated for 5 years. There is going to be SafeP, so you're going to SafeP. That's an inpatient drug treatment. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be proof of employment within 45 days of release, no employment as a home health care provider or with minors. There's to be 200 hours of community service restitution. There's to be no contact with Walmart. There's to be no contact with minors. There's to be the theft course. Probation, is there anything else? There should be field visits one time per month until further notice. And he's to remain in custody until transferred to safety. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I'm not trying to be dumb or anything. I don't understand what's going on if I was gonna get probation.
No, I gave you probation, but you need treatment for your drug problem.
I don't
That
have a
drug-
drug problem.
Okay, then you're just stealing for no reason.
I don't have a drug problem.
So that means you're just stealing for no reason.
It was just dumb choices. I don't
Alright.
have any kind of drug problem.
So here's the thing. I've given you a legal sentence. If you do not want to sign for SafeP, let me know and they'll file a motion to revoke. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. So what I can tell you, the conversation you had with me, you told me you were using heroin. What I read in the police report, when they had the stolen items with you that they recovered, they mentioned also, I contacted Detective Burban and advised him of S1's arrest. CSI Worthington field tested the substance that you had and it tested positive for methamphetamine. So that's why you're going to inpatient drug treatment. We're off the record, but if you don't want to go, probation will go over conditions with you. If you don't sign the conditions for probation, they'll file a motion to revoke. And then counsel, if you want to be appointed for that motion to revoke, what will end up happening, if your counsel wants to waive notice, we'll have a hearing on your motion to revoke today.
I tell Attorney Chapa.
All right, thank you.
Thank you, Your Honor. God bless you.
God bless you too. Thank you. Court is calling 2025 CR 0055590. State versus Joseph Santos. Could I have parties announce?
Duffy Pitlock for the state of Texas, Your Honor.
Michelle, for Mr. Santos?
All right. And is there an application in this case?
There is, Judge.
Okay. Put this. And is he applying for deferred adjudication?
Yes.
All right, counsel, have you received all discovery? And did you review it with your client?
I have that.
Court will find that the state is in compliance with discovery. Mr. Santos, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Santos, did you review the court admonishments with your attorney? Did you understand it and sign it
Yes,
in all the appropriate places?
yes, ma'am.
All right. You're charged with evading an arrest detention with a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering into this plea bargain agreement, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He did, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is, Your Honor.
Mr. Santos, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, yes.
According to the plea, there's to be a $2,000 fine. State is recommending deferred adjudication. This will run concurrent with 2024 CC 739065. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions? Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation, 200 hours of community service restitution, the aggressive driving course, and the MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objection.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we would just ask the court to follow the plea bargain.
All right, how old are you?
I'm 24.
24. Do you have any children?
Yes, ma'am.
Why are you doing this?
Honestly, I just made a mistake. I made a dumb choice that day, and honestly, I'm just taking whatever punishment.
You're just lucky to be alive.
Yes, ma'am.
Thank God you're alive, right?
Ma'am.
Because what you did, this is not like a video game where you have 5 lives and you crash out, then you get another life. You understand?
Yes, ma'am.
I can't tell you the number of times that I've been driving and you have people who want you to respect motorcycles, want you to respect people who are riding on bicycles, but they're not following the rules of the road. Do you know, I was driving on 410 and there is a guy passing by me on a motorcycle going excessive because I'm going the speed limit. He passes me, so he's going faster than I am. He's going above the speed limit and he's doing a wheelie on the freeway. My heart was just start racing. All I could do was pray that he doesn't cause an accident and he is not in an accident. And you are trying to outrun the police on a motorcycle and then you crash out. So how did you crash out?
I honestly, I had tried slowing down and turning, and I slipped up and I fell, and that's honestly how I ended up
Did
falling.
you see your, people always say you will see your life flash before your eyes. Did you see your life flash before your eyes?
I can't say I did. It was a low speed crash, but I did know it was a stupid mistake. I could have died that day, and I don't want to do that and put my daughter through that.
No, you could have died. And then the way you were speeding, other people could have died. The officers could have died. And then you know what would have ended up happening? You would have been on some post somewhere where somebody's trying to do a GoFundMe and they were talking about, can we raise money for his daughter because her dad is dead? You understand?
Yes, ma'am.
So have you had employment? And I'm sorry, state, you may be excused. Have you been employed?
Yes, I have.
Doing what?
Honestly, multiple jobs. I've been employed Amazon, construction, doing my own business, landscaping. I've honestly been trying to do everything I can to just stay out of get myself out of trouble. And I'm just trying to do better for myself.
So where is this motorcycle?
It's in an impound. I never pulled it out since. I never have tried getting another bike since.
Okay. All right, there's going to be a $2,000 fine that will be probated. Regular reporting by Zoom or in person. Regular random UAs. proof of employment within 30 days. Yes. I'm sorry. All right, there's a $2,000 fine to be probated, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, 200 hours of community service restitution. I'm going to order parenting classes. Once those are completed, 100 hours will be waived for parenting. How far did you go in school?
I was forced to drop out in 11th grade to start working to help my mom out with bills. She had lost her job.
All right, so if you obtain your GED or some sort of trade school certification, then the court will deduct the remaining 100 hours.
Like HVAC and stuff like that?
Mhm.
Okay.
So whether you spend those 100 hours picking up trash, that's usually what they find for you to do in the heat. You can do that, or you can improve yourself. Do you understand?
Yes, Your Honor.
There's going to be field visits 1 time per month for 4 months. The aggressive driving course. And this is to run concurrent with 2024 CC 739065. And you're not allowed to drive any motorcycle until you've completed the aggressive driving course. So no operation of motorcycle until completion of the aggressive driving course. And no driving any vehicle without proof of a valid driver's license and insurance. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, Your Honor.
All right, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal? Yes.
I apologize.
Thank you so much. That will be 4 years deferred adjudication. He'll walk away like, oh no, I'm done. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing, I see that you have a lot of municipal court violations. You had better get that corrected. Do you understand?
Yes.
And I'm serious. You're not allowed to drive any vehicle until you present to probation a valid driver's license, yours, and proof of insurance. Do you understand?
Yes, Your Honor.
All right. Good luck to you.
Thank you.
You're
Thank you, Your Honor.
welcome.
God bless.
Oh, you. God bless you too. I love to receive blessings. And I think there was a warrant issued, so I'll ask that the warrant be recalled.
Thank you.
Oh. No, but I added other things, so it should be somewhere. Yes, well, no, it should be on another motion that he signed. I'll do that in a moment. Yes, another motion that I did, because I added extra conditions. Richard Cantu.
I'm bless you, Your Honor.
Oh, thank you. God bless you too. Hello, are you all ready to proceed on this?
Yes, Your Honor, it's an MTR. I have to make a little bit of a record about some.
All right, the court is calling 2021 CR 11554, State versus Richard Cantu. Can I have parties announced?
Megan Galloway for the state.
Meredith Chacon on behalf of Mr. Cantu.
And are you Mr. Cantu?
Yes.
All right, in defense, you wanted to place something on the record?
Yes, Your Honor. I was appointed to this after the MTR was filed. In looking at the case history, I wanted to note that Mr. Cantu had originally been found incompetent
did the jail-based competency program and attained competency in part because he was given the Abilify injections while in the jail. When he got out on his probation before I was appointed, apparently that the injections were not something that he was still taking. So when he got picked up again, the last time we were set, I had requested a competency evaluation. By the time he did that, he was back on the Abilify injections. So we had a short hearing last week in the magistrate court about his competency. I feel confident that he is competent today. But it is because he's taking those injections, and that's part of what our agreement is today with regard to his probation.
All right, so here's my question. So with regard to his competency evaluation, did that judge already sign the order stating that he's competent?
Yes, we did that hearing last week.
All right. So we're here on the motion to enter adjudication of guilt and revoke community supervision.
Yes.
Did you review that document with your attorney? Did you understand it?
Yes.
Are you the same Richard Cantu was placed on deferred adjudication in 2021 CR 11554 for the offense of obstruction or retaliation on September 16th, 2024 for a period of 3 years? Is that you?
Yes.
All right, state.
Violation of condition number 4 in Bexar County, Texas. The defendant, Richard Cantu, did then and there fail to report to the supervision officer as directed for the months of December 2024, January 2025, in violation of condition number 4.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
All right, the court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, after conferring with counsel and the probation department, we are asking that you deny the state's motion and alter and amend the defendant's conditions for mixed supervision and bi-weekly reporting for 3 months and monthly UAs and compliance with meds.
Yes, Your Honor, that's understood.
All right, so here's my understanding of things. I understand when people have mental health issues, but while he's out, nobody can force him to take the injections. So, Mr. Cantu, these are your choices today, and these are the only 2 choices you have. I can revoke you. If I revoke you, what's going to end up happening is you'll go to prison, and I'll sentence you to 3 years in the prison. You'll get credit for any time that you've been in custody, or I can continue you. And if I continue you, and if you end up being revoked, you're looking at least 10 years. I can't force you to take your medication. That has to be a completely separate hearing for you to be given the injections. But you know, your counsel knows that if you don't take the injections, what's going to end up happening is you're going to lose competency. You're not going to report. You're going to be picked up. And when you're picked up, you're going to be placed in custody. They are going to give you your medications and you'll work your way through the system. And if they need to force you to take medications, they'll have a hearing on that. A court order will then be entered and they will force you to take your medications. You will be competent and then we'll be right back here. So do you have one, if you want, I'll sentence you to 3 years today. Or if you want to be continued, is there anything in place other than probation coming to see him biweekly to make sure that he takes his medications?
If I can ask him a couple of questions, because I do think he has more of a plan than before.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Richard Cantu.
All right.
Richard, in talking about your case, there were a couple of issues that you had when you got out last time. One of those being you have difficulty reading, correct?
Mhm.
Okay, and you have to say yes or no.
Yes.
Okay. And also, you had issues finding where you were supposed to go to check in. Is that right?
Mhm.
Okay, so since then, have you reached out to your family, specifically your sister?
Yes.
And what is your sister's name?
Cynthia.
And has Cynthia promised that she'll help you get where you need to go this time?
Yes.
And have you arranged for a doctor that you have that's going to continue you on the Abilify injections?
Yes.
Do you know the name of your doctor?
Yes.
What's his name?
Ray, Valerie.
Okay, and you are comfortable with being supervised by the mental health unit? You think that'll be better for you?
Yes.
And you understand if for some reason your doctor can't do this, that you're gonna need to ask probation to help you connect with the Center for Healthcare Services.
Yeah.
Okay, and do you feel like you have the resources to do that?
Yes, I've got the inside.
So are you asking this judge to allow you to stay on probation and try again, or do you want to be sentenced today to 3 years? Which thing?
Be put in probation.
Okay, okay.
All right. Probation, is there anything else that we can do to make sure that he continues with his meds?
Judge, other than, me making a note in the system, to ensure that his officer is aware of all of the issues, I think the mixed supervision is what's best.
All right, so then I'll deny the motion, follow your agreement, alternate amend conditions to include the mid caseload. The last time he didn't have a place to stay, so he was going to be staying at Haven for Hope. Do you have a residence?
No.
So to be Haven for Hope?
Yes.
All right. Off the record for a moment. All right, so we'll do the mid caseload. And then I'll say reside at Haven for Hope until we find another placement for you.
Okay.
So everyone will be working towards getting a placement for you that will help you with the mental health issues, plus provide housing.
Thank you, Judge.
You're welcome. So we'll place him on the mid caseload. And I'll just say referral for housing. And you to reside at Haven for Hope until alternate housing is available. You know, it'd be nice since he's currently stable on his meds, it would be nice if he can get into Twin Village. Is it called Twin Village or Twin Town Village, or either Town Twin Village? Just one of the two. Let me see.
Okay, good.
Yeah, it's called the Town Twin Village. So if you counsel, if you're going to look into that, it's TOWNE, Twin Village.
Okay.
And it's through the city, but they'll be able to tell him what he needs to do to get registered to be considered for housing there. And they have everything right there at the site, a place where he can go talk to a doctor, those type of things. All right, is there anything else that you need from me, counsel? All right, here's my concern about biweekly reporting. I think biweekly reporting is great, right? Because somebody can check on him or have him come in to see if he's staying on his medication. But the downside to that is he has mental health issues. He's staying at Haven for Hope. You all think that would be too much?
I think, given the issues that I just know briefly what you all have been discussing, we could also assign him to our central office, and have him placed with mental health officer. That would be the only thing. I mean, we could work in communicating with the NIC manager, but keep him downtown since he's going to be at Haven. It'll be more convenient for him to not have to go out of his way to report all the way on the south side.
All right,
That
so
would be helpful, Judge, because that is one of the barriers is like the transportation, and he knows where the things are downtown, but.
all right, so we'll do downtown reporting. And then we will do it bi-weekly.
And I'll place an email to the NIC manager to see if he can work with our mental health officer and identifying services for residential or somewhere he can stay.
All right, so we're gonna do, we'll do bi-weekly reporting until further notice. What will end up happening
Just, I do have my sister's house to stay in my sister's house.
Well, let's try to make sure you stay stable,
Yes,
and we're gonna see if we can find a place of your own, okay?
okay,
So let's first make sure you're stable when you are not in custody,
okay.
and then we can see about everything, because sometimes it's hard when you just dropped into a relative's house,
Yes.
because everybody has their own rhythm and flows of how the rules are in the house. And then when somebody comes in, whether it's family or not, you know, it happens to me when I visit my mom, there's already a rhythm and a flow, and I'm disrupting it a little bit. Like, people are happy that you're there. They love you. They want you to be there. But let's try to get you situated first, and then we can see about other options, okay?
Yes.
So we'll do bi-weekly reporting until further notice. And what will end up happening is they will send me a compliance or a letter stating, hey, he's already stabilized. We no longer need to do bi-weekly reporting. But it's just for us to make sure that you follow through on everything, okay?
Okay.
Is there anything else you need?
No.
All right. Good luck to you, Mr. Cantu.
Thank you, Judge.
Thank you. Court is calling 2020 CR 9618 State versus Ricky Thatcher. Could I have parties announced?
Megan Galloway for the state.
Nick Aguilera, on behalf of the Honorable Ricky Thatcher.
All right. Are there any applications in this case?
No, Your Honor.
All right. And are you Ricky Thatcher?
Yes, Your Honor.
Counsel, have you received all discovery that you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Thatcher, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving the repeater enhancement and the deadly weapon allegation and count 1. We are proceeding on count 2, but we have a motion to proceed on the lesser included offense of possession of a controlled substance, PG1, 200 to 400 grams. And then we are proceeding on counts 3 and 4 as is.
Any objections?
No, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right. And count 2. The state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, 200 grams to 400 grams. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Count 3 is evading arrest detention with a vehicle. Count 4 is felon in possession of a firearm. Those are third-degree felonies. Range of punishment for each of those is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow that plea. If for any reason the court does not follow that plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
All right, if you could initial there. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Judge, could you give me 30
Yes.
seconds? What are you for? Yes. Okay, it didn't like you were correct. I apologize, Judge.
Okay.
He was born here in San Antonio, and I forgot to mark that off.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Thatcher, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on counts 2, 3, and 4. They're proceeding on the lesser included offense in count 2 of possession of a controlled substance, penalty group 1, 200 grams to 400 grams. Punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. there are no applications, and the state will take in consideration 2025 CC 009785. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to count two, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
To count three, how do you plead? Guilty, not guilty, or no contest?
No contest.
To count four, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the defendant's plea.
State offers states one in attachments.
And for the purpose of this plea, Judge, we have no objection.
All right, state, you may be excused. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Thank you. Oh, I think this is a county court.
Take it. I thought they handed it to me to hand to you.
All right, no problem. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty of counts 2, 3, and 4, and the court will find you guilty of counts 2, 3, and 4. Are you proceeding with sentencing?
You would consider going straight to punishment, Judge. There's no application. We're not applying. We know we're going to TDC, and would ask you to consider the recommendation of 8 years TDC.
All right. This is what the court will do. And count 2, the court will sentence you to 8 years in the prison. And as previously stated, the court is finding you guilty of counts 2, 3, and 4. And counts 3, the court will sentence you to 8 years in the prison. Count 4, the court would sentence you to 8 years in the prison. Counts 2, counts 3, and counts 4 are running concurrently, and legally they have to run concurrently. There's to be credit for any time served. Take in consideration 2025 CC 009785. There's to be a $2,000 fine, and there's to be no contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony, because this is a felony conviction, and because you waived your right to appeal. I'm sorry, just 1 second. There's something popping up on my computer. I may have a virus. We shall see. All right.
You'll
Because-
open that virus.
Yeah, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You have some decisions to make about your life. You understand?
Yes, ma'am.
Only 1 or 2 things will happen in the business that you're in. Number 1, the money that you make, that's the fast money. I bet you don't even know where it went.
It's not worth it.
And it's not worth it. And because when you do this, you are building your happiness off someone else's misery. And that's never a good thing to do. Do you understand?
Sure.
All right, good luck to you.
Thank you.
You're welcome.
God bless you.
Yes. Thank you. God bless you too. Thank you. All right, Julio Hernandez. Hello.
How you doing?
I'm doing okay. How are you doing? Is there an application in this case?
No application, Your Honor.
All right, the court is calling 2025 CR 004341 State versus Julio Michael Hernandez. Could I have parties announced?
Megan Galloway for the state.
Thomas Silafedi.
And are you Mr. Hernandez? All right. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, on the cause number ending in 04341, we are proceeding as is. And the cause number ending in 6712.
Just one moment. I didn't call that case
Okay,
because
sorry.
no, my fault. All right, the court is also calling 2025 CR 006712. And that case number as well, counsel, have you received all discovery and did you review it with your client?
Yes, Your Honor.
And that cause number, the court will find that the state is in compliance with discovery. And in that cause number, Mr. Hernandez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
And state, in that cause number, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count one of that indictment.
Any objection?
No, Your Honor.
Mr. Hernandez, in each of the cause numbers, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
And each cause number, you're charged with unlawful possession of a firearm by a felon. That is a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering into these plea bargain agreements, you were giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hernandez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine, no applications. The case will run concurrently. The state will take in consideration 2025 AL 002409. And in the cause number ending in 1-2, the state is proceeding on count 2 only. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney in each of the cause numbers? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motion?
None, Your Honor.
Then in count 2 and cause number 2025 CR 006 712, how do you plead? Guilty, not guilty, or no contest? And in cause number 2025 CR 004341, how do you plead?
Guilty.
State any evidence.
State offers states one in attachments in each cause.
No objection in each cause.
All right, state you may be excused. In each cause, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Please, Your Honor,
Anything you wish to say on behalf of your client?
please, respectfully, we beg this court to go along with the plea bargain made.
All right. And cause number 2025 CR 006712. The court will sentence you to 5 years in the prison, give you credit for any time served. There's a $2,000 fine. This will run concurrent with 2025 CR 004341, taking consideration 2025 AL 002409. Is there anything else with regards to sentencing in that cause number?
No, Your Honor.
And the cause number 2025 CR 004341. As previously stated, the court is finding you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served. There's a $2,000 fine. This will run concurrent with 2025 CR 006712. The court will take in consideration 2025 AL 002409. And each of those cause numbers, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, hear me clearly. You are not allowed to own or possess any weapon or ammunition. If you do, that's against the law. Do you understand?
Yes, Your Honor.
If you don't know what that means, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. We're off the record. How old are you?
I'm 31.
All right, you're 31. And let me just tell you, if you come back in Texas for another thing, another offense that's a felony, oh, people say they won't, and then I end up seeing them back. Let me just tell you,
Wrong for that.
you're habitual.
Yeah.
That means that depending on the specific case, either you're looking at a minimum of 25 years in the prison, you're not eligible for probation, or either you're looking at up to 20 years in the prison, regardless. Do you understand?
Yes, ma'am.
So either you're gonna stay straight and fly right, or either you're not.
Yes,
All right, good luck to you.
Thank you.
Good luck.
Sir.